standstill traffic at the Chanmari flyover. Yes.
May please.
1 second, just one judgment.
Technical appeal 10/2019.
Appeal dismissed.
May please. My lord, in respect of item 10, I have taken the consent of my learned friend who represents, my lord, the petitioner. Lordship may kindly accommodate me for the day after vacation, my lord, on 28th or 29th.
The judgment is already delivered. Yes.
My lord, in respect of item 10, I have taken the consent of my learned friend who is representing the petitioner. Lordship may kindly accommodate me for the day after vacation on 28th, 29th.
Item 10.
10, my lord.
You are for?
I'm for the Corporation Department, my lord. Respondent.
As prayed for by Mr.
SK Taluk.
SK Talukdar and Standing Council, Cooperative Department, which is not opposed by the other side, list this matter after 2 weeks on a date to be fixed by the registry. Yes, please.
May it please, Your Lordship. Item number 9, my lord. And I may appear on behalf of my lord, respondent number 5, my lord. My lord, at least, my lord, on section 20, my lord, file an affidavit, my lord. regarding
Is the microphone on?
Yes,
Yes,
I am for the petitioner.
Is the microphone on? Yes. In item 9, you want to file something.
So I might file an affidavit on behalf
You are
of
for the respondent
respondent
5. As prayed for by Mr. N. Bora, learned counsel for respondent number 5, with consent from the petitioner, list this matter after 2 weeks to enable the respondent to file counter affidavit in the matter.
He has also one pair, my lord. He has not received any copy of the affidavit by the government.
The government said I have received.
Okay.
From the
Who-
government side, I have received, my lord, but from the
No, no,
respondent
I'm
side,
not-
yes.
I'm not.
Anyway,
Sorry,
yes,
Mark.
please, next matter.
Right.
Mr. Sharma?
May it please, Your Lordship. Your Lordship, item number 43, we have filed an affidavit in opposition on behalf of respondent number 5. I pray that it may be called on record because we have filed it today morning.
Yes.
Obliged, Your Lordship.
May please, Your Lordship. Lordship, I want to mention regarding item number 31 of daily list. Matter may be adjourned for the day, and we have taken the consent of other side.
I'm for
31.
Yes, Lordship. Learned counsel is
I'm appeal for respondent 1 and 4, my lord.
You are for?
petitioner.
As prayed for by MS N. Khatu.
U Nanda.
And item 31.
Yes, Lordship. On
MS
behalf
U
of jail
Nanda,
officer.
learned counsel for the petitioner, list this matter after 2 weeks on a date to be fixed by the registry.
I'll have-
Much obliged.
May I please, Your Lordship. Lordship, I have to mention item number 12, Lordship. Lordship, matter became infractions, Lordship.
Your name?
PJ Dutta.
Heard Mr. PJ Doctor, learned counsel for the petitioner. Also heard
M. Kalita, my lord, for the
Mr.
private
M.
respondent.
Kalita for respondent number 9.
Yes.
Mr. Datta, learned counsel for the petitioner, submits that the writ petition in the meantime has become infractious. Stop. In view of the aforesaid endorsement, the writ petition is then dismissed on being infractious.
Obliged.
Disposed of.
May it
Obliged.
please, my lord. I beg to mention for listing 1 IM, my lord. Your Lordship dispose of this matter, my lord.
All right. Next.
May I please, Your Lordship? Lordship, I beg to mention for item number 35. Lordship, in this case, Lordship, I has been filed for implement of the new incumbent in the circle of.
The IA is not listed today.
No, Lordship.
In item 35, list this matter after 2 weeks on a date to be fixed by the registry, along with the interrogatory application filed therein.
May I please,
Obliged.
Your Lordship. Lordship, with the consent of the other side, Lordship, I beg to mention item number 4, Lordship. Lordship, may
Yes.
adjourn for the day, Lordship.
You are for?
And Industries and Commerce Department.
As prayed for by Mr. A. Kalita.
Yes, on behalf of N. Kalita.
Your name?
N. Kalita.
N. Kalita, on behalf of Mr. A. Kalita, Learned Standing Council, Industries Department, with consent from other side.
Yes, Lordship.
List this matter after 2 weeks on a date to be fixed by the registry.
Obliged.
May it please, Your Lordship.
Yes, Mr.
I wish to mention item number 3 and 21
3 and 21.
may not be taken by your lordship, as these were represented.
All right. Item 3 and
3
21.
and 21.
Not before me.
But 20 is different, lordship. Your Lordship.
In item 3, not before me. Huh? 20 and 21, what do you want, Mr.
Lordship,
Talukdar?
20 is different, lordship. It is clubbed with 21. Lordship.
Whatever be it, what do you want today?
Lordship, I will do 21, lordship.
Huh?
Or I will do 20, lordship. Item number 20. 21 is infractions also. Lordship.
to say that in item 21, Lekha, that heard Mr. H. Talukdar, learned counsel for the petitioner, stop. Yes, who's appearing for the other side? Also heard MSJ Deka Gogoi, J. Gogoi, learned standing counsel, Dima Hasao.
Yes.
And Mr. C. Hajorika, learned government counsel for the state respondent. Mr. Swenso Talukdar, learned counsel for the petitioner, submits that the matter in the meantime has become infractious. In view of the aforesaid endorsement, the petition stands dismissed on being infractious, disposed of.
20 is not infractious, Lordship.
Yes, I know. This order is only for 21. 20, the 20 will be called out.
May I please, Your Lordship? Firstly, I beg to mention item number 19, Lordship. The engaged counsel is out of station, Lordship, for some medical reason.
Your name?
D. Datta, Lordship.
As prayed for by MSD Datta, learned counsel for the petitioner on the ground that the arguing counsel, Mr.
SB Laskar, Lordship.
SP Laskar, is out of station due to medical treatment, which is not opposed by the other side. List this matter after 2 weeks on a date to be fixed by the registry.
May it please your Lordship. Lordship, I beg to mention item number 24, Lordship.
What do you want?
24, Lordship. In this matter, Lordship, respondent number 2, 3, 4, 5, and 7, Lordship, had filed their affidavit in opposition, Lordship. And another affidavit.
You want to
was
file
filed-
counter?
Lordship,
Rejoinder?
3 weeks time.
As prayed for by Mr.
N. Gautam, Lordship.
N. Gautam, learned counsel for the petitioner, list this matter after 3 weeks on a date to be fixed by the registry to enable the petitioner to file rejoinder to the counter affidavit filed by the respective respondents.
Lordship.
Call the list.
Order no step, item number 1. May I please, Lordship?
Yes, steps.
Yes, we have taken a step on last 26/9 of 2024, Lordship.
When did you take steps?
26/9/2024, Lordship.
26/9.
Yes, Lordship.
Office note dated 6/9/2024 indicates that no fresh steps as required has been received in respect of respondent number 3 and 4. However, today when the matter was called, Mr.
MM Zaman.
M.M. Jamal, learned counsel for the petitioner, submits that fresh steps has been taken
Yes, sir.
on
26/9/2024.
26/9/2024.
Yes, Lord.
Stop. Let registry verify and place an up-to-date report. List after 2 weeks on a date to be fixed by the registry.
Item 2. May I please, Your Lordship?
Madam, newly engaged earlier set of where is not there, my lord. And a group of employees changed, my lord. I am newly engaged. my
You'll
lord.
be newly engaged
Yes, my lord. I have already taken fresh steps again, my lord, on 27/9, my lord.
on 27 then.
And yes.
Office note dated 2/9/2024 indicates that steps for fresh steps for service of notice upon respondent number 6 as directed earlier by this court has not been taken. However, Mr.
A.K. Talukdar.
A.K. Talukdar, learned counsel for the petitioner who has been newly engaged in the matter, submits that fresh steps as required was taken on
27/9.
27/9/2024. Let registry verify and place the same on and place the up-to-date report before this court. List after 2 weeks on a date to be fixed by the registry.
All right.
Item 5, 6, and 7.
Yes, what are these matters? 2018
This
matters.
matter, we are supposed to file affidavit. Affidavit is ready, Lordship. Within a day or two, we'll be filing, Lordship.
So we are fixed in the month, 2nd of November.
M. Bhattacharjee, learned additional senior government counsel, submits that the affidavit in opposition is ready and the same shall be filed within a day or two. Within
Within a week, Lordship.
Within a week. Stop. List this matter. Reopening or after 2 weeks or
The month of November, 2nd
November.
Not 11th. Obliged, Lordship. Item 8.
In the meantime, if you want to file a rejoinder,
Also, I'll file.
in the meantime, should I say? All
So,
right.
let's let them file.
All right. Yes. Item 8. Yes, Mr. Chakraborty.
Lordship. Matter relates to Lordship, appointment of compassionate ground, Lordship.
No affidavit filed till now.
Lordship.
Yes.
What I'll be submitting my case is a bit covered in the earlier judgment. Initially, what happened, Lordship, at the time
It's a compassionate appointment.
compassionate appointment, at the time of the filing of this case,
Covered, Ms. Bhattacharya. Yes, Mr. Chakraborty.
what happened at the time of filing of the case, the law was the scheme prevailing at the time of the death of the incumbent will be relevant. But subsequently, law changed, and it is taken that at the time of consideration, the scheme prevailing will be taken into consideration. So in this case, what happened?
But Mr. Chakraborty, this is a compassionate matter.
Yes,
It is now 2024.
Lordship.
There has been a long delay.
Lordship.
Debabrata Tiwari is there.
This fact has also been taken care of.
When did who died?
Father died.
Father, when?
It died 21/2/2013. Lordship.
21?
2/2013.
13.
Yes.
An application?
A application was filed immediately on Lordship 5/4/2013.
5/4/2013. 13. And then
What happened?
then nothing happened.
DLC recommended my case.
When?
DLC recommended my case on 1/6/2015. 3/6/2015. Lordship.
3/6/2015. 15.
And
then
Lordship, what happened? It was placed before the SLC. SLC on 22/11/18 rejected my
22/11
2018 rejected my claim without assigning any reason.
And when did you file this petition?
Lordship, this is my second round of litigation, Lordship.
When is the first one?
First one? What happened? This honorable court was pleased to
When
direct
did you file?
the first one.
Yes. These dates are important.
Lordship.
But you see, admittedly, from 2013 to 2018, you have not done anything to pursue the claim.
No, what happened? DLC recommended my case.
Correct. But you see, Mr. Chakraborty, what is the object of compassionate appointment? Correct.
Yes,
Now,
Lordship.
suppose you had filed the application in 5/4/13.
Lordship.
Till 15, it appears DLC was also sitting silent.
Lordship.
In this period, you could have always come before the High Court.
DLC ultimately in the
No.
after DLC.
You see, when otherwise the sense of immediacy gets diluted.
What happened? Non-consideration of my case by the SLC. I approached this honorable court in the year
When?
in the year 18.
That is right. But your father died in 13.
13.
From
After my
13 to
approach-
18,
After my
14,
approach-
15, 16, 17, 4 years.
4 years. What happened, Lordship, in this case? As per the
Yes, Ms. Are you filing something?
No, Lordship. Lordship, may kindly peruse page 25, Lordship. At the top, name of the petitioner is there, Lordship, Gautam Bhagavati.
Yes.
Lordship may see the office of the Chief Engineer, PWD Roads, Assam, Guwahati,
Yes.
HSLC Pass, Junior Assistant, already filled up with 5% quota.
Rejected.
Lordship, there is 5% quota reserved for the compassionate appointment, Lordship.
I am not on the merit. I am on the because if
The
you
delay
apply
part-
Debabrata, then this matter becomes time barred.
Yes.
that the delay part, Lordship, what I will be submitting has been taken care of by this honorable court in a judgment passed in 2020, Lordship.
Sure.
Lordship, may I pass another judgment covering my case? Lordship, the second one, paragraph number 4 and 5. The second one, that is Dipankar Roy, paragraph 4 and 5.
Paragraph
4 and 5. One page judgment, Lordship.
ঠিক হয়েছে তাতে?
তাতে একটা reason দিব লাগে।
No, the reason is there.
reason is to give
Reason
in,
is there.
Mr. Chakraborty.
Lordship,
Reason is there.
Lordship,
Reason is given
Yes.
what happened?
at page
25.
page
25.
25. Already filled up within 5% quota.
Yeah.
What more reasons?
Yeah.
What happened, Lordship? The
One second. Which is this Neil Kamal Roy? Which paragraph?
Neil Kamal Roy, Lordship, page para 7, Lordship. Para 7, Lordship. May I read, Lordship? Sri Karita, learned counsel for the petitioner, submits that the impugned decision of the SLC to reject the case of the petitioners for appointment on compassionate ground with the reason that more than 2 years have elapsed is wholly unfair and would amount to discrimination of the petitioner with similar citizen person. On earlier occasions, the case of the petitioner were rejected without assigning any reason, and even after remand by this court, the ground taken
Facts are
by the
different.
SLC rejection on the ground that is not acceptable by law. the landed council submits that no fault can be attributed to the petitioner if their cases were not considered within 2 years. And what is material to be taken into consideration in such cases is as to whether they had applied for appointment on compassionate grounds expeditiously and within a specific time. It is submitted that in all 4 cases, there is no dispute that the application submitted by the petitioner were immediately after the death of their father, and in any case within 1 year from the date of such death.
All right, Mr. Chakraborty, you had mentioned that you had come earlier before this court. Where is that order?
Lordship. Lordship, find it relevant part is page 19, Lordship.
Page
19, Lordship. It starts at page 15 and 19, Lordship.
This is at the stage where SLC was still not.
Yes, yes. And Lordship, that the judgment I just placed before this honorable court.
Do you have the date on which you had filed that petition?
This petition?
That's a first petition. Do you have the date?
I don't have the date because I think Lordship it was disclosed.
Yeah, ma'am, you get that date because it has some bearing. You see, I have been dismissing the writ petitions of similar nature on a particular ground that the petitioner has also not done anything to approach. Here, since it appears that in 18 after DLC you has come, so maybe that may have some bearing. So I want to have a, all right. In case I want to, there can be an exception to your case. Because
only Lordship, while I was submitting para 4 of that judgment of Lordship Dipankar Roy.
You see, para 4 of Dipankar Roy, I can deal with it right away because your case is different. In your case, there has been a reason assigned.
The reason they stated that only vacancy.
Whatever that reason is there, it is. You cannot say this is a case of where no reasons have been given. Reason correct or not, that is a different aspect.
In this
but a reason
also,
has been given.
In this case also, Lordship, similar reasons also.
Anyway, we will.
Lordship, let us try, Lordship.
You get that,
Lordship.
Mr. S. Chakraborty, learned counsel for the petitioner, seeks 2 weeks' time to obtain instruction as the date on which WPC 6587 of 2018 was filed by the petitioner before this court. List accordingly. List after
probably the matter has become infractuous.
Yes, Mr. Bora.
Yeah.
Infractious?
Infractuous because the term of the petitioner was for 5 years with effect from 2018.
So I can record your submission and dispose it of. Heard Mr. D.P. Bora, learned counsel for the petitioner. Also heard Mr. J.K. Goswami, learned additional senior government counsel for the state. What is the challenge here?
My lord, the petitioner was appointed as honorary deputy advisor video Village Defense Organization.
And then subsequently removed.
He has been terminated by an order dated 20.
By way of this petition under Article 226 of the Constitution of India, the petitioner is assailing the impugned order dated 31/12/2020, whereby the services of the petitioner as honorary deputy advisor video Hojai was terminated. Stop. Mr. Bora submits that the tenure of the petitioner has already been expired and accordingly makes an endorsement that the matter has become infractious. Stop. In view of the aforesaid endorsement, the writ petition is then dismissed on being infractious.
Obliged, my lord.
Well, last occasion.
Some instruction, Mr.
Yes,
Bora.
yes, last occasion, the lordship directed to produce the taxation petition manner.
Whether it is sub judice before the civil
Yes,
court.
in this case, well, your lordship go to the Schedule A, my lord.
Schedule A.
Schedule A, my lord.
Yes.
There is a PLI policy number so and so, life insurance policy number, leave salary, GIS amount, leave education, death come, retirement gratuity, and GPF. Now, out of this, my lord, 3, I think both petitioner and private respondent are already getting, my lord, but divided by 2. And there is a stay order pursuant to the honorable court order regarding the family pension. This I am the unmarried daughter, my lord. That was also modified by this honorable court. And there is a pair, my lord, the repetition of pair in the repetition, my lord, go to show that they only came before the honorable courts, my lord. They until disposal of the miscase of the succession case, my lord, not to release, to stop the process release of pensionary benefit, my lord. Pensionary benefit of my mother already released. I am receiving salary pursuant to the modification order passed by this honorable court on 21/12/2021.
Where is that? The prayer is to stop.
My lord.
Shall not issue directing R2 and R3 to stop process to release pensionary benefit in the
My
name
lord.
of R4.
My lord.
And that you are saying you are getting.
Yes, my lord, pursuant to the modification order.
Where?
My lord, there is a IA, my lord.
IA
In the
trust.
before, my lord, that's my lord, repetition, there is a stay order. In the thereafter, my lord,
Where is the
filed
stay order?
my lord, stay order, my lord, in
In this petition.
petition, my lord.
I think
First, my lord.
24/8/2021 order.
Yes, my lord, 24/8/2021. And thereafter, I file a miscase, my lord, for modification and vacation of the petition. I am the unmarried daughter, my lord.
And then in which I?
My lord.
Okay.
Thereafter, IA, my lord.
So anything remains?
No, I think, my lord, there is a
The prayer is not only to the family pension. Family pension being an unmarried daughter, she will get. We are not opposing that. Our only prayer is the retirement benefit. Retirement benefit, the petitioner being the son, if he is equally entitled for the 50% of the equal portion of the retirement. That's what we are paying. We are not paying for family pension that she is getting. She being an unmarried daughter, Lordship.
You want what? The retirement benefit?
Lordship. Other like Lordship.
That retirement benefit is not part of the civil suit.
No, Lordship, retirement.
Yes, my lord. And
Retirement
there is
benefit.
no pair of the repetition. my lord.
No, but that retirement benefit, death come retirement gratuity.
First, Lordship, we have.
And where is this retirement benefit prayer in your
No,
petition?
nothing.
Lordship, retirement benefit, like Lordship, the gratuity and all, Lordship, there are some pending.
Where is it? That prayer.
Their prayer on the
One
page
second,
12.
Mr.
my lord.
Their
Bora.
benefit.
1 second, Mr. Bora.
They
Where
are
is that
saying-
prayer?
Yes, Lordship, will find at page 13.
Page 13.
Lordship.
Yes.
Prayer number 4, Lordship.
Yes.
This
Not
prayer
to
number-
release any pensionary benefit
Yes.
in the name of R4 until disposal of the miscase pending adjudication before so and so.
Yes.
So that the petitioner may not be deprived from his legitimate right to get equal portion of so and so.
Death benefit, yes. Death benefit is Lordship retirement. Where I am. So my,
Not there. Whatever is there.
yes.
Your prayer was not to release the pensionary benefit. This is your
Pensionary
only
benefit
prayer.
doesn't only mean that only the pension. We are not insisting on pension.
Mr. Counsel, I am reading your own prayer.
Yes.
Correct?
Loss.
First of all, your prayer is that,
Yes.
and already by this court it
Order,
has
yes,
been
that has
given.
been recognized.
That has
Yes.
already been taken care of, and it appears there is some civil case which is pending, where the retirement benefit, everything is already sub judice.
Yes.
Then what remains
No.
in this writ petition?
No, Lordship, retirement benefit not in subjudice. Lordship. We switch that. Initially, Lordship, the respondent authorities issued a letter directing this petitioner as well as respondent 5 to provide their details like Lordship bank account and all. So initially, she Lordship agreed with this petitioner that they will take 50-50 of the retirement benefit. Thereafter, Lordship, she sends her mind, Lordship, and said that she is the Lordship only unmarried daughter and she will only get all the benefits. Then only the question of this succession certificate and all has come.
Correct, but so that dispute is pending.
Yes.
Can this
Lordship
court?
can dispose of this petition directing that the respondent may not release the death benefit, Lordship, the retirement benefit until disposal of the succession case. Otherwise, Lordship, she will get everything, Lordship. Already she has.
That case is pending. You contest that case.
No, Lordship,
Is that case
has been
over?
filed by us, Lordship. This
You have
petition,
filed it.
yes, for
So,
succession, Lordship.
you contest that case.
Only Lordship succession case, Lordship. My prayer is only Lordship to not
So
to release.
you want to say that till that succession case is decided,
Yes.
the debt
Benefit. Yes.
benefit
May not be.
it may not be released.
Yes, Lordship.
Mr. Bora?
That is actually
Minor.
moot. There is no-
That was already both petitioner as well as private respondent already getting the
No,
minor.
sir, if
As
the-
per instruction, leave salary getting,
Yes.
life
Others-
insurance policy getting,
still other is pending.
DIL policy getting, GIS
Which
getting.
instruction? From where are you saying?
In page number 21, Lordship, I have annexed the schedule, Lordship.
This is a schedule, minor. I am
of the-
schedule. I am saying.
this, succession
No,
case,
this is what they are claiming, or this is what they are getting.
After minor, during the pendency of the succession of both are minor amicably settled, minor. They received the both minor.
If she is agree, Lordship, to get 50-50, then Lordship, there is no dispute.
No,
Lordship.
no, this court is not getting into
Yes.
all this.
There is no pair, minor. Just to injunction, not stop the. And already that order was vacated.
All right. You are Mr. Kalita.
Lordship.
Heard Mr. J. Kalita, learned counsel for the petitioner. Stop. Also heard Mr. N. Bora, learned counsel for respondent number 4. And Mr. J. K. Goswami, learned additional senior government counsel for the state respondent. Stop. By way of this writ petition, comma, filed under Article 2 to 6 of the Constitution of India, the petitioner is seeking direction to the respondent number 2 and 3 to stop the process to release pensionary benefit in the name of the respondent number 4 until disposal of the miscellaneous case within bracket succession number 10 of 2020 pending adjudication before the Honorable District and Session Judge Nagaon, which is stop. The facts of the case is that the petitioner's mother, late Lavanya Das, who was working as CPA at Dairy Development Office, Bureau Bevigia District, Nagaon, Assam, died on 1/12/2019, leaving behind her. Who is the petitioner?
Yes, son, Lordship.
Leaving behind her son, within bracket present petitioner, and her daughter, within bracket respondent number 4. Stop. Thereafter, on 31/12/2019, the Office of Dairy Development Officer, Nagaon, issued letter to the petitioner and respondent number 4, whereby they both were directed to submit necessary documents such as bank account details, next of kin certificate, etc., for the purpose of processing and availing the government benefits as legal heir of the deceased mother. Stop. Not government benefits, retirement benefits. Retirement benefits, not government. Next part. Upon receiving the said letter, comma, the petitioner though requested respondent number 4 to avail the retirement benefits available to them in equal portion, comma, the respondent number 4 having not giving the appropriate response, comma, the petitioner filed an application before the District Judge Nagaon for grant of a succession certificate being miscellaneous within bracket SUCC case number 10 of 2020. Stop. Thereafter, the petitioner also filed an objection before the Directorate of Dairy Development by letter dated 16/2/2021 with a request to stop the process of sanction of the death benefits and family pension to the respondent number 4 till adjudication of the aforesaid succession case. Stop. Thereafter, on 23/2/21, a letter has been issued from the office of the Dairy Development Officer, Nagaon, to both the petitioner and respondent number 4 to once again requesting them to submit the necessary papers for processing the retirement benefits. Thereafter, on 3/7/2021, the respondent number 3 submitted the documents of respondent number 4 for processing compassionate family pension. Without waiting for the disposal of the succession case. Stop. Aggrieved by the aforesaid, the present writ petition has been filed. Stop. Heard the parties and perused documents. It appears that this court on 24/8/2021, when the writ petition was moved, after hearing the prayer for interim relief, was pleased to restrain the respondent numbers 1, 2, and 3 from releasing and or distributing compassionate family pension. Where is the word compassionate has come from now?
Initially, there was a system of compassionate appointment.
Compassionate family pension amount to any of the legal heirs of the deceased mother until further orders of the court. Stop. Pursuant to the aforesaid interim order, upon an interlocutory application being IAC 1297 of 2021, being filed by the respondent number 4, this court, after hearing both the parties, which is that modification, this is some correction.
Correction. There's the IA.
IA task. Which is the IA number, Mr. Bora?
IA number. IA number 2267.
So that IA is not here. Do you have the order?
Yes,
number? Please give the IA number.
2267.
2267.
Oblique 2021.
An interlocutory application has been filed. Being IAC number
226 oblique
2267 of 2021, wherein this court, after hearing both the parties, was pleased to modify the aforesaid interim order, and direct the respondents to process.
Or the respondent authority shall at liberty to release the family pension.
And was pleased to direct that the respondent authorities are at liberty to process
release the family pension in favor of the respondent authority.
Modified the order, aforesaid interim order dated 24/8/2021, by directing the respondent authorities that they are at liberty to release the family pension in favor of the respondent number 4, appellant, pursuant to order dated 5/8/2021, issued by the Joint Secretary to the Government of Assam, addressed to the Accountant General within bracket ANE, Assam. Stop. In the aforesaid order, it was further clarified that except the family pension, other pensionary benefits of the petitioner and respondent number 4 shall not be released to either to the writ petitioner or to the respondent number 4. Stop. It appears that the succession case is still pending adjudication before the district and session judge, Nagaon. Stop. In view of the aforesaid, this court is of the opinion that this writ petition can be disposed of with a direction. Mr. N. Bora, learned counsel for the respondent number 4, submits that in view of the aforesaid order, the respondent number 4 has been receiving the family pension.
Compassionate family pension.
Huh?
Compassionate family pension.
As an unmarried doctor.
Stop. Then you say, in view of the aforesaid, Asan had done, this court is of the considered view that this writ petition in the interest of justice can be disposed of with a direction not to release the other pensionary benefits of late Lavanya Das unless pending adjudication of MSC stop case within bracket succession number 10 of 2020, pending adjudication before the Honorable District and Session Judge, Nagaon. Stop. It is made clear. It is needless to be clarified that that upon the succession certificate being adjudicated, the respondent authorities shall be at liberty to release the other pensionary benefits in terms of the succession certificate granted by the succession court in accordance with law.
I'm filing affidavit. There is a I am categorically stated Rule 143.
That's all right, Mr. Bora. You see this.
Not entitled,
Whatever be it, that succession certificate is pending adjudication. It makes no sense of keeping this petition pending here, disposed of. All right. The order to lagi up premise. Item 13 is na. Disposed of. Yes, anyone appearing in 14? None appears for the petitioner when the matter is called list after 2 weeks on a date to be fixed by the registry. Lupa. Manoj,
last occasion, standing on PWD, seeking time to
1
fight.
second, please. Yes,
On last occasion, my lord, 49/2024, my lord.
3 weeks time, Mr. Petitioner, you are required to serve a copy of the petition to Mr. Gogoi.
My lord, already served.
Yes. Yes, what happened? Mr. Gogoi? Who is going to file return?
PWD.
Huh?
PWD.
Where is PWD? Why are you waiting in the side? Yes?
Lordship, we are yet to receive instruction, Lordship.
So come forward and assist the court. Why are you waiting in some corner to be called by the court? I'll run that some further time. As prayed for by?
On behalf of Mr. Ardha, Lordship.
Huh?
Mr. Ardha.
Your name?
Tishisanla.
MS so-and-so learned counsel appearing on behalf of Mr. R. Dhar, learned standing counsel PWD, comma, which is not opposed by the other side, list this matter after 2 weeks on a date to be fixed by the registry to enable the respondent to file their return in the matter.
In this case, also, my lord, no affidavit has been filed, my lord.
Who is going to file?
Irrigation department.
Irrigation, Mr. Upadhyay.
Lordship, BTC is supposed to, Lordship. BTC authority is supposed to, Lordship.
What about irrigation? Mr. Borwa, you have filed Accountant General, or your role will come later?
Later.
Yes. BTC?
Proposal has to come from the BTC, Lordship.
How many councils are there for BTC? Because this court has been observing. You are for BTC?
Lordship, Mr. Pinayak is on legs.
So I will say you all file whatever you have to file. This is it. Huh?
Lordship.
In fact, a covered case, my lord. Sandita Rana.
In fact, they have taken time to file affidavit in this case, Lordship.
This is covered, but subject to, because it will be returned back.
Let them file their
That is covered. Some
as prayed for by MS
A. Bothakur.
A. Bothakur on behalf of Mr. P. Nayak, Learned Standing Council, BTC, list this matter after 2 weeks to enable the BTC to file their return in the matter, which is not opposed not by the petitioner.
Item 17.
Yes, Mr. Dev.
This is regarding non-payment of pension.
Family pension affidavits also not filed.
Not filed.
Yes, Mr. Gogoi. I
Lordship,
see you are carrying a voluminous instructions. Looks like.
No, Lordship. This is a transfer subject. This is Dima Assault, and we receive instruction. The appointing authority will process everything, Lordship. In fact,
Appointing authority will be?
Dima Assault, Lordship.
No, they will be processing.
Yes, Sir, Lordship.
Yes, if you are processing, then I can dispose it off by giving a time frame.
Our role is to forwarding the papers, and we have forwarded the same
To whom?
to the Deputy Commissioner, Lordship. He is working under Deputy Commissioner Dimahasa.
Who is appearing for the Deputy Commissioner? Yes. When will you
17.
Give the family pension? It's a 23 matter. How can a pension matter be kept pending?
The petitioner, the husband of the petitioner died on 6/8/21.
Standing council has been appearing, so today we have been appraised that the deputy commissioner has to do lordship.
No, it's you see, it becomes very difficult when
Yes,
the
Lordship,
respondents
as
keeps
a-
on shifting
Yes, Lordship.
to one another.
We also
See,
find it
as far
very-
as this court is concerned, you all are part of the one
Yes,
organ.
Lordship.
This court is really not concerned how internally you are functioning.
Lordship.
The issues pertaining in this cases, the issue arising out in these writ petition appears to be of some serious nature. Correct?
Lordship, I
Family
have-
pension matters
Lordship,
from
I
2020.
understand,
From
Lordship.
when? It's pending since when, Mr. Dev?
It is 6/8/21 expired, but what has happened, Lordship? They say, at page 22, if Lordship kindly comes to me.
Page 22.
This is the letter of the Superintendent of Excise, addressed to the Accountant General.
Yes.
This was of 25th of November 21.
Yes.
The AG comes and says that this letter was never received, my lord.
Who says?
The AG. If your lordship kindly comes to the order dated 22/2023 of this honorable court, my lord.
Yes.
This letter was never sent.
It says not received. No, but now today Mr. Gogoi is saying Mr. Gogoi, this is under process now according to you?
No, as per our instruction, Lordship, we received that the appointing authority will process the pension and gratuity proposal in respect of the husband of the petitioner, Lordship. And the appointing authority is a Dima Hazara, Lordship. And
No,
as
what
per-
is the status? See, this court is now only concerned about the status of this 25 November 21.
Exactly, Your Lordship.
This has been sent from Dimahasa to the accountant. Who
Accountant
is
General.
appearing for the accountant general? What is the status of this letter? Because as per order dated 22/2/23, you have taken your Mr. Medhi has taken a stand that this has not been received. So in that case, why don't, instead of going into all this controversy, let Dimahasa resend this to the Office of Accountant General. Let them do their part and send it.
Only thing, my lord, not only below pension, my lord. The provisional, nowadays, my lord, this is a compassionate family pension, my lord, because the compassionate appointment has been done with. My lord, in that place, my lord, nowadays, my lord, the scheme is the salary, last draw salary is being given to the family papers. Here in this case, my lord, not even the GPF
I
gratuity.
have understood, Mr. Day, but unless and until they process, will you get
Only thing,
anything?
you know, the
What is important right now?
No, my lord, only thing
Because
that-
no one is disputing your claim. There is no one has come up saying that you are not entitled.
No, there
Correct.
is-
Now the question is about processing. It appears that there is a stand as regards that this letter itself has not been received. Now, why should unnecessarily we waste more time into all this?
No, no,
It
I'm
would
not,
only
I'm not on that. I mean,
correct.
see, Milord,
What do you want from this
Milord,
court
in fact, the
today?
provisional pension has to be given, Milord. That is what I'm saying, Milord. There's an interim prayer also, Milord. Now, Lordship 2021, 6/8/21 was the date of death, Milord. Initially, we whatever documents were required, Milord, we placed. How will the family survive, Milord? Almost last 4 years.
Where is the interim prayer?
Page
11,
14, Milord. 13, 14. This is to be paid, otherwise paid within 6 months, Milord.
Mr. Day, I think I can dispose this petition by directing them to do all this, whatever is to be done
Exactly.
within a time
With a
frame.
specific time frame.
There is no requirement otherwise keeping this matter pending. Huh, Mr. Gogoi?
Very well, I agree.
All right. Ms. Bhattacharjee?
Lordship.
There is no point of
Yes,
keeping this
Lordship.
matter pending.
Yes, Lordship.
Correct?
Yes, sir.
Heard Mr. R. Day, Learned Counsel for the petitioner. Stop. Also heard Mr. R. Gogoi, right?
Yes, sir, Lordship.
For respondent number
1 and 2.
For respondent number 1 and 2, and MS J. Gogoi for 3 and 4. MS M. Bhattacharjee, Learned Additional Senior Government Advocate for respondent number 5, and MS RR Saikya for respondent number 6. On behalf of Mr. S.K. Medi for respondent number 6. By way of this petition under Article 226 of the Constitution of India, the petitioner is seeking finalization of the family pension papers and releasing the same to the petitioner. Stop. The facts of the case is that the husband of the petitioner, who was serving as a lower division assistant in the establishment of the Superintendent of Excise Dima Hassan Haflong, died on 6/8/2021 while in service, and although the pension papers were forwarded to the Accountant General within bracket ANE Assam by the Superintendent of Excise Dima Hassan by letter dated 25/11/2021, the pensionary, the family pension and other pensionary benefits, i.e. gratuity, group insurance scheme, leave encashment, general provident fund, etc., has not been released to the petitioner. Stop. Heard the parties, peruse the relevant materials available on record. It appears that on 22/2/2023, Mr. S.K. Medi, the Learned Standing Counsel, appearing on behalf of the Accountant General, submitted that as per the instruction received from the Senior Accounts Officer of the Office of the Principal Accountant General within bracket ANE Assam, no family pension application as mentioned in Annexure D to the writ petition have been received in that office. Stop. He further submitted that in pursuance to the order being passed by this court, the Senior Accounts Officer have also written to the Secretary to the Government of Assam, Excise Department, the Commissioner of Excise, as well as Superintendent of Excise, Dima Hassan, to furnish the pension application along with the original service book of late Chandrika Sahini in complete and correct shape to enable the office to take necessary action. Stop. It further appears that the office communication, the said office communication furnished to this court by Mr. S.K. Medi has been kept on record and marked with the letter X. In view of the aforesaid submission made by Mr. S.K. Medi, this court on by order dated 22/2/2023 directed the Standing counsel appearing on behalf of the Commissioner of Excise as well as respondent number 3 and 4 to obtain instructions as to when the annexure D to the writ petition was sent and as whether the Office of Accountant General have duly received the same. Stop. Today, when the matter is called, Mr. R.R. Gogoi, learned standing counsel for
Excise
for
Department.
the appearing on behalf of the Commissioner of Excise, submits. Yes, please give that. Submits that a letter dated 28/10/2022 issued by the Additional Commissioner of Excise Assam to Additional Commissioner of Excise Assam has been furnished to him by the office, wherein it is informed that the appointing authority will process the pension and gratuity proposal in respect of late Chandrika Shahini, ex-LDA, who was posted in the Office of Superintendent of Excise, Dima Hasao. Stop. Late Chandrika Shahini is the petitioner's
Husband.
husband. Husband is Chandrika Shahini.
Yes, ma'am.
Husband is Chandrika Shahini.
Within bracket, a naam to likhila. Petitioner's husband, correct?
Yes, yes, yes.
Petitioner's husband.
Chandrika.
And Accountant General, your stand is that you still have not got it. Keep perusing the aforesaid instruction, including the earlier instruction dated 27/2/2023, this court is of the considered view that this writ petition can be disposed of with a direction to the respondents to process the pension and gratuity proposal in respect of the petitioner's husband, i.e. late Chandrika Shahini, ex-LDA, in accordance with law. Stop. It is ordered accordingly. It is needless to be clarified that the respondents, particularly Excise Department, the Commissioner of particularly the Excise Department. I'll just simply say Excise Department or Secretary to the Government of Assam. Who has to send these papers?
The paper is sent by Superintendent of Excise.
Particularly Superintendent of Excise, Dima Hasao, to furnish the pension application along with the original service book of the petitioner's husband incomplete to the Office of the Accountant General.
To the Office of Deputy Commissioner.
To the Office of the Deputy Commissioner.
And thereafter Deputy Commissioner forward the
Dima Hasao.
Dima Hasao.
Whereafter the Deputy Commissioner Dima Hasao shall forward the same
to the AG.
To the
AG.
Within bracket Principal Accountant General. A and AG or to the AG?
AG, Accountant General, ANE.
To the Office of the Principal Accountant General within bracket ANE, Assam. Stop. Whereafter no, I don't think anything is to be said that full stop. It is needless to be further clarified that the entire exercise shall be carried out within a period of 3 months.
3 months, sir.
3 months from today, from the date of receipt of the certified copy of this court's order. I think everything is covered. With the aforesaid observation and direction, this writ petition stands disposed of.
Highly obliged, Lord.
A copy of the letter dated 28/10/22 is kept on record and marked as X. Let me keep it on
X is
record.
already there,
Sorry,
X1 or something.
Y.
All right.
In this case also, my lord, no
17,
affidavit
no?
has been filed.
Disposed of. Yes?
No affidavit has been filed, my lord.
Yes, what about affidavits,
Yes,
Mr. Nayak?
not yet filed, Lordship, but
As prayed for by Mr. P. Nayak
Yes,
and Mr. N. Upadhyaya. Learned counsels for the respondents list this matter after 3 weeks on a date to be filed by on a date to be fixed by the registry to enable the respondents to file return in the matter. It is needless to be clarified that the returns shall be positively filed by the next date of listing.
Oblige.
Instruction. Yes, what is the status of instruction? Have you received?
Yes, Lordship.
Arrear salary, Mr. Talukdar.
Yes, Lordship.
Since when have you not received the salary?
Since Lordship 1/8/2017 to 28/2/2020.
It is 2017.
1/8/2017.
Yes.
To 28 February 2020.
Non-sanctioning of financial or of supplementary demand is not a ground for denying the arrear salaries. It's for a substantial period. How can the arrear salary be not paid? We are in 24 now. This is for 1/8/17 to 28/2/2020 for almost 3-4 years salary. And this matter has been filed in 23. Till date, no affidavit. This matter was fixed today for specific instructions.
Lordship, that is my latest instruction, Lordship.
You file an affidavit, but this court is not satisfied with this. It cannot be simply saying that additional fund is not given. So that is the only ground, unavailability of fund. So then I will dispose it off and by saying that you release it
Lordship. And moreover, Lordship,
within three months.
in the last financial year, Lordship, 1,22,70,000.
No, I'm not going on that. You see, because the instruction does not dispute the claim. It only says that you have not been able to release because of the unavailability of the supplementary fund which you had demanded. Correct?
Yes,
if that be so, while there is no way out, you have to pay it. You cannot not pay the arrear salary.
Yes, Lordship.
Right? Heard Mr. H. Talukdar, learned counsel for the petitioner. Stop. Also heard Mr.
C. Sharma, Lordship.
C. Sharma, learned.
Standing Counsel, Dima Assam. 4 and
Standing
5.
counsel, Dima Hassan. Mr. Yes, you are appearing?
Copy deputy lordship.
MS.
Respondent tree.
MS.
Toshi Sanna.
So and so, learned standing counsel, PWD. Mr. A. Chaliha, learned standing counsel, finance. Finance. Anyone else? GA is there? No. GA is there. I think Ms. Bhattacharya, you are there. Just have a look. I'm recording it. MS M. Bhattacharya, learned additional senior counsel for the state respondent. In the cause title, GA is shown.
There's one Lordship.
By way of this petition under Article 2 to 6 of the Constitution of India, the petitioner is seeking direction commanding the respondent authorities to release the petitioner's entitlement, i.e. arrears salary for the period 01.08 2017 to 28/2/2020 Stop. The facts of the case is that the petitioners were appointed on different dates but before AFRBM period, i.e. 1st September 2005, either as MR laborer or fixed pay employee or casual employees under the respondent number 5. Their services were regularized later on.
No, they were brought under the minimum pay scale, Lordship.
Where is that?
The Annexer D, Lordship.
It is the specific case of the petitioners that pursuant to the orders passed by this court in WA number 45 of 2017, correct?
That's it.
17. WA, sorry.
Followed by WA, one notification was published by the Finance Department. And accordingly, they were brought under the minimum pay scale.
Pursuant to which order? Pursuant to the notification dated, pursuant to the notification dated 8/3/2019 issued by the Finance Department in terms of the judgment rendered by the division bench of this court in WA number 45 of 2014, comma, the respondent number 5 by order dated 29/6/2019 brought the petitioners to the minimum pay scale and has been paying the same with effect from 1/3/2020. Stop. Since the arrears with effect from 1/8/2017 to 28/2/2020 has not been paid, comma, the petitioner approached before this court by filing WPC number 5160 of 2022, wherein, comma, this court by order dated 30/8/2022 directed the respondent number 5 to submit a demand for budget allocation. Stop. It appears that the respondent number 5, thereafter, the respondent number 5, by letter dated 9/9/2022, submitted the said demand before the respondent number 3, but the same was not accorded. Situated thus, the present writ petition has been filed. Stop. Heard, perused, huh? Today, when the matter has been called for admission, comma, Mr. C. Sharma, learned standing counsel, Dima Hasao, submits the instruction received from the Office of the Executive Engineer, PWD, within bracket RNB, Maibang Division, Maibang, Dima Hasao, dated 1/10/2024, whereby it is informed that there is no remaining pending salary as regards Rajdeep Boro, petitioner.
No, it is not.
That is item number 20, Lordship.
It is informed that pending arrear salary as claimed in the instant writ petition is not yet paid, as the supplementary demand proposal is not yet sanctioned by the Finance Department. Stop. A copy of the aforesaid instruction is reproduced hereunder for ready reference, A to A. Apparent reading of the aforesaid instruction that the subject arrear salary is not being released to the petitioner due to the non-sanction of the finance department. Stop. In view of the aforesaid instruction received, this court is of the considered view that this writ petition can be disposed of with a direction to the respondents. Anybody in particular I have to give, because I am saying that you release in accordance with law. Respondents to release the pending subject area salary to the petitioners in accordance with law within a period of 3 months from today. Anything else to be added?
Lordship, I'll just like to add one thing. Lordship, here my learned friend has relied, Lordship had recorded notification dated 8/3/2019. Lordship, there was another notification which superseded this because here.
But you see, there is already one case.
Yes, Lordship will just specify as per that case. Lordship, instead of the notification, Lordship.
Mr. Chalia, once the order is typed out, I will tell my court master, Mr. Talukdar, Mr. Chalia, just have a look.
Lordship.
If anything factual aspect, any change or date has to be given, please indicate it to the court master. I will edit it accordingly. All right. 3 months colon with the aforesaid observation and direction, this writ petition stands disposed of. To his succession case. Succession case. Yes.
Lordship, say in terms of this honorable
Compassionate appointment.
Lordship, here, my lord, in terms of this honorable court's order, my lord, that matter has been remanded back to the SLC, and SLC already been considered my case, my lord.
Then?
And my lord, that Lordship kindly have a look at SLC, my lord.
Okay, SLC has considered.
Yes.
SLC has already considered, but
Considered.
the earmarked vacancies
And,
for the compassionate appointment has already completed in serial number 22, and the petitioner's number was in serial number 23. So he is in waiting list number 1, Lordship. And as there is no earmarked vacancy for compassionate appointment, so
Now, since
we are not able to
2022,
appoint
my
him.
lord.
We have already
Today, Lordship,
No, but her Ms.
more than-
Kotoki's submission is that because of no vacancy, it has not been given. Otherwise, till 22, it has been done. You are at serial number 23.
And that part, my lord, Lordship kindly have a look, my lord.
You said like this court can dispose it of today. What direction you are wanting?
My lord, since there are so many vacancies, my lord, and that has not been taken into consideration, they are not taking into
Where from are you saying there are so many vacancies?
Yes.
Where from you're saying there are so many vacancies?
Only from, my lord, I have stated in my writ petition, my lord,
No,
that
because of want of vacant post only, you have not been accommodated. Yes.
my lord,
The department is animal husbandry. So from the department, it has to come that till now, whether the vacancy is available or not.
Correct.
If the police
Correct. Can this be disposed in this way? Because it appears that SLC has otherwise considered.
Yes.
Now about vacancy and all that, this court is not an expert or will not be able to say anything. But this court can always dispose, saying that as and when the vacant or first to assess if there is a vacant post, and as soon as the same arises, then to accommodate.
Below than me, my lord, Lordship have a look, my lord, one letter written by them, my lord.
See, I am not going into all that because there is how can this court go into all these questions?
Yes.
It doesn't appear
No,
there is
I'm-
any arbitrariness or anything wrong. Your case has already been considered.
Already
Now
been-
it is only posting you. Correct.
That in the letter, my lord, written by them, my lord, already below than me, my lord, they have been already appointed.
Is that position correct? Anyone
Yes.
below the
Fort-
petitioner has
48.
been? Huh?
48, page 48. Lordship.
Page
48, Lordship.
48.
It is their letter, my lord.
48.
Yes. 48 and 49, Lordship will see. They written by director to the principal secretary to the animal husbandry. Now,
This is not now against the vacancy in cultural affairs department. The name of Vipul Radha stands at serial number 1 in the selected eligible list is proposed for appointment.
may be considerable, Lordship.
two numbers already been appointed, my lord.
They were below or
Yes, below.
Is this
Perhaps,
aspect?
perhaps below, because he is in, the petitioner is in serial number 23, and as department instructed,
No,
he is
they
in
are-
waiting list number 1. If that is
Yes.
so, this number is
They are below than me.
perhaps below. If it is
Whose number? Whose number is below?
that annexure.
This Bipul
that-
Rabha.
Yes, Lordship. Perhaps I'm not sure about
Can
that.
you have the updated instructions?
Lordship.
You file an additional affidavit. So technically the position has to be clarified. Who will file? Both of you, or you will file?
Lordship will specify regarding this.
Mr. B. Chetri, learned counsel for the petitioner, by drawing the attention of this court to the letter dated 30/1/2023 enclosed as Annexure 6 to the writ petition at page 48, has submitted that persons below in the select list, persons below of the petitioner in the select list has been appointed, and accordingly the stand of the state authorities that due to want of vacant posts, the case of the petition, the petitioner could not be appointed on compassionate ground is fallacious. Stop. Mr. C.K.S. Borwa, learned standing counsel.
No, GS.
Learned government counsel for the state, seeks 2 weeks time to clarify the set, above. Stop. Prayer is allowed. List after 2 weeks on a date to be fixed by the registry.
Deeply obliged.
Lordship, here I am seeking 2 weeks time to file affidavit, Lordship.
All right. As prayed for by Ms. M. Bhattacharjee, learned additional senior government counsel for the state respondent, which is not opposed by the other side, list this matter after 2 weeks on a date to be fixed by the registry.
Much obliged, Lordship.
Obliged, Your Lordship.
Yes.
My lord, instruction not yet received, my lord.
Receive.
Not received, my lord.
Not received.
My 24 matter, my lord. I need some more time, my lord.
Even if it's a 24 matter, the issue is pension.
My lord. My lord. He was retired long back, my lord. His
I
father
do
and
not
mother.
understand how matters pertaining to pensions, various salaries, and gratuity department takes so much time.
My lord.
Even if it's a 24 matter,
Yes, my
the
lord.
notice was issued in the month of March.
My lord. My lord.
We are almost
employee was
approaching the end of the year.
employee was expired.
Anyway, you take your time.
My lord.
I'm
He
giving
was
you
retired on 96, my lord.
your
So
name.
S. Datta.
As prayed for by Mr. S. Datta, learned counsel,
Standing counsel PNRD.
standing counsel PNRD, list this matter after 2 weeks on a date to be fixed by the registry to enable the respondent to file their return.
Obliged.
Obliged.
Area salary, instruction.
Pension and area salary.
Pension also.
My lord, other benefit. I am not even getting Lordship.
You on the last occasion you wanted to reconstruct
Yes,
this
Your
file.
Lordship. Actually, the personal file of the petitioner got missing, and
Have you been able to reconstruct?
we have reconstructed till 2016. However, Your Lordship, certain new developments could have come out, Your Lordship, by now.
What?
The thing is that after 2016, the petitioner's service, it could not be found. If I read it, Your Lordship, the
Yes.
instructions we have received, it is to be mentioned here, since 2016, no modification of transfer order related to Sri Hajong was issued by this office. As a result, Sri Hajong was not working in any subordinate office from 2016 to the date of his retirement, that is 2024. So after 2016, we don't have any record, Your Lordship.
So who will give those records?
Lordship, otherwise the petitioner could not be found in service after 2016, Your Lordship. Because
but the petitioner claims to be in service.
My lord, he was not in service because
He was not in service
No.
after 2016.
No,
After
2016, Your
whatever Lordship.
Then you file whatever
Yes,
you
Your
had. You
Lordship,
file
I'll file an additional affidavit. Your
Mr. G. Bordeler.
Lordship.
Mr. G. Bordeler, learned standing counsel for corporation department, submits that he has received some instruction in the matter which he seeks to place on record. Prayer is allowed. List after 2 weeks on a date to be fixed by the registry.
And a pension matter, I am not getting Lordship provisional.
All right, let him file.
Lordship, can it be on 30th of November?
Okay. Can you file it by then?
30th of November. No, yes, Your Lordship.
30th November, date.
October,
Obliged, Lord.
30th November is a Saturday.
It's 30 October, Lordship.
Can you file it?
Lordship, I'll file
All right,
immediately. on the
30th
email.
October. Yes.
Obliged.
Appointment to post of Gao Pradhan. Yes, call. Yes. Who is stopping your appointment?
My lord, actually,
AO is filed. What about rejoinder?
my lord, here the government filed the affidavit. They also clarify that there is a two posts, my lord. One is Bolimara Part 1, another is Bolimara Part. So my father was appointed Bolimara Part 1. I was selected Bolimara Part 1. But the person who approached this honorable court, he was not a candidate, no participant in the process, my lord.
Please, you are not filing rejoinder.
Not requirement. Already they clearly stated, my lord. They filed their affidavit, my lord. Kindly see the annexure, my lord.
Ms. Bhattacharya, what is the stand? Why the
Lordship,
appointment?
actually,
Here, the prayer is for appointment.
yes, Lordship, report was there that under this Alitangani Moja, there were two Lordship. Two lots. That, yes, Lordship. Then subsequently, Lordship, advertisement was called, selection was also done. Subsequently, Lordship, it was found that no, there was only one Lordship, where only this another person has already been appointed Lordship. Yes. And the report was also called from the circle officer. Circle officer in turn had asked the report from the Lakmandal Lordship. Wherever it is given Lordship, and the annexure is very clear, Lordship. If your Lordship kindly with the vernacular one, page 50 of my affidavit, Lordship.
Yes.
The vernacular portion, Lordship, I am reading. Second para, Lordship.
Yes.
লাটমন্ডলৰ সৰজমিন তদন্তক্ৰমে দেখা যায় যে আলিটাঙনি মৌজাৰ 1 নং বৰালিমাৰী কিসামত পূৰ্বতে দুজন গাঁও প্ৰধান আছিল আৰু উক্ত গাঁও প্ৰধান দুজন হল আব্দুল খালেক আৰু আব্দুল হাকিম। আব্দুল হাকিমৰ লাটত তেওঁৰ বুৱাৰী জেছমিনা খাতুনে ইতিমধ্যে গাঁও প্ৰধান হিচাপে নিযুক্তি লাভ কৰি লাটমণ্ডলৰ কামসমূহ চলাই আছে। পূৰ্বতে এই কাৰ্যালয়ৰ পৰা দিয়া বৰালিমাৰী কিসামতৰ ঠাইত 1 নং বৰালিমাৰী অংশ হ'ব লাগে। অন্যহাতে উক্ত 1 নং বৰালিমাৰী কিসামতত পূৰ্বতে উক্ত গাঁৱৰ অংশ হিচাপে গাঁওবুঢ়া কামত আব্দুল খালেকে কামসমূহ চোৱা চিতা কৰি আছিল। আব্দুল খালেকে নিযুক্তি পোৱা নথি তদন্ত কৰা হয়, দেখা যায় যে তেওঁ সদৰ মহকুমাধিপতি নগাঁৱৰ পৰা পোৱা নিযুক্তি পত্ৰখনত অংশ বুলি লিখা আছে।
I'm giving you a last opportunity. You want to file a rejoinder or you don't want to file a rejoinder. Otherwise, I can dispose it off against you. So if you want to file a rejoinder explaining the situation, please avail it.
Yes, my lord. My submission there, my lord. My father was appointed, my lord.
You are not filing a rejoinder.
My lord, we will file, my lord.
So then just file a rejoinder, explain this, because otherwise I will take them as admitted if you don't deny it. As prayed for by Mr. Sorry? HR?
H. Ali, my lord.
H. Ali, Learned Counsel for the petitioner, list this matter after 2 weeks to enable the petitioner to file rejoinder to the counter affidavit filed by respondent number 4.
Hello.
On a date to be fixed by the registry log ID.
Last petition 3 weeks time was.
Yes, Mr. Gogoi.
Lordship, we are awaiting instruction, but thing is that his service was a contract for 2 years, Lordship. And he has been, it is not an order which you have
You
challenged.
file your affidavit.
Very well, Lordship.
As prayed for by Mr. R.R. Gogoi, and Standing Counsel, Forest Department, list this matter after 3 weeks to enable him to file return in the matter.
My lord, may I pray for a fixed date, my lord? Otherwise,
It will come. Yes.
Item 29.
Yes, Mr. Bhumik.
Lord, I pray for
Transfer.
the petitioner. The respondent state has filed affidavit, but has not served copy of it.
This thing is that he has not been.
Yes, so you give him.
I'll give you in the course of that day also, because I have only one copy right now.
All right, you give him. Until unless you give him, we cannot
Perhaps you want
proceed.
to file one reply also.
It is submitted by Mr. P. Bhomik, Learned Counsel for the petitioner, that a copy of the
Affidavit in opposition
filed by the respondent has
State.
not been.
Respondent state.
Has not been served upon him. Stop. Mr. C.K.S. Borwa, Learned Government Counsel, State, shall furnish the copy of the said return within the course of the day. List this matter
After vacation, Lordship.
after 2 weeks on a date to be fixed by the registry.
Lordship, the earlier interim order needs to be
Interim, if
extended.
any, shall continue till the next date of listing. This is that part that you are supposed to give. Is it prepared?
Just Lordship, I am troubling one thing. Malum ne kindly clear that compilation file by the R. Mozumdar Lordship. In page 189 Lordship. Page 89 to 107 Lordship.
Page
89 to 107.
Anybody from Mr. Chaudhary side? No juniors of Mr. Chaudhary is there? Should I take this up after the orders?
No, Lordship, just last time
Yes,
just
page 189.
Only 89 to 107 Lordship.
89 to
107.
Yes.
And my lord, kindly come to page 107 Lordship. 107 Lordship.
You want me to flag first 89?
89 Lordship. 89, it starts from 89. It's a affidavit filed by the petitioner Lordship before this honorable court Lordship in the.
And you want me to now go to 104?
10 Lordship. 107 Lordship.
107.
107.
Yes, matters which require urgent consideration.
Lordship.
Yes.
And 106 also Lordship. Kindly page 106 Lordship. 106 first portion Lordship.
106. Yes.
First portion Lordship.
Yes. Till
Lordship should consider the place and accounts officer either at Shillong or Guwahati. If it is done, the employees can be retained in service up to 60 years instead of 59 years, Lordship. That
I'm not getting that part.
Lordship, it is a part of the paragraph 8, Lordship, where it says that, Lordship.
No, I am at 106.
Lordship.
I'm not getting what you're reading.
It is in top portion, Lordship. Top first. 106.
Okay.
Top portion, Lordship.
If it is done.
If it is done.
Please read.
Lordship. If it is done, the employee can be retained in service up to age of 60 years instead of 59 years, Lordship. As on Lordship, 2006 Lordship, as per the affidavit filed by the director before this honorable court in the Sila Borse case, Lordship, at the relevant point of that age is 59 years, Lordship. And that was also, Lordship, reiterated in 107, Lordship.
Have you put this in your?
I put it. Just I indicate, Lordship. And Roman 4 107, Lordship.
So that relevant time, the age was 59.
59 years as per their affidavit. But what is troubling to me, Lordship, in Lordship 25/5/99 itself, they have says that, Lordship, Executive Committee adopted the Constitution, Lordship. But Constitution's, Lordship, it says that, Lordship, 3 categories, Lordship.
66. Right, 60, 65,
60, 62, and 65.
60, 62, 65.
65. And they have filed the affidavit before this honorable court in the PI, Lordship. They have says that it's 59 years, Lordship.
They mean?
The authority of the LGBI, director himself, Lordship.
They say this is their affidavit.
This is their affidavit, Lordship. That's why, Lordship, something is there. So, Lordship may examine too. Yes, because otherwise they on oath.
That's why from the day one I've been
Lordship.
telling Mr. Gogoi
Lordship.
that age is not clear.
Lordship.
What is the age?
Lordship.
Because if you have noticed, subsequently the argument got
Lordship.
Modified to the extent that now it is the parity which they are seeking.
Lordship.
But for parity, you have to show that you are under the same organization and under the same organization, someone discharging the same word. For in that case, the age of superannuation is.
If we Lordship has rightly pointed out at the relevant point of time when they have entered is a 58 years, Lordship.
That you are showing from that that notification that you had handed over, right?
That notification.
That shows 58.
58 years. Now,
And here the affidavit shows it's 59.
Their affidavit itself says
But
that.
be that as it may, even if you assume this to be 59 or 60, it is less than what it has been now enhanced to. Correct?
Nowhere they are deprived, Lordship.
So at that time, if we go by this, he wasn't entitled to superannuate at the age of 70. So one cannot say that anything detriment has been done.
that cannot be.
That cannot be.
Others,
And then the other thing that you all are saying, because now because that itself shows that clause 6 that the terms and conditions since are yet to be set. The moment it is set, anything that nothing should be detrimental to the interest. Correct. Now suppose the age is not less than what it was, then that is not detrimental. This is one thing. Second thing is that thereafter the constitution will come in force, so the terms and condition will be in terms of the constitution. Now here one argument is brought in that inherited employees, the constitution will not come, but those are signed by the board, are made by the board themselves, wherein the petitioner is one of the signatories. Correct.
Others also, Lordship, that as per the division bench judgment of our High Court, Lordship, they are bound by the terms and conditions of the Constitution, Lordship. Paragraph 14 and 27, especially paragraph 14 and 27, it was stated there. Their service condition will be governed by the Constitution, Lordship. There is no dispute, Lordship. Otherwise, Lordship, if we go by the affidavit, Lordship, which they have filed in 2006 before this honorable court in the PL in Chila Borse cases, Lordship.
This is that affidavit.
This is the affidavit, Lordship.
This affidavit is filed in WPC 3287.
Lordship. 3287 1996 Chila Borse, Lordship. In this case, Lordship, then Lordship, either Lordship that affidavit, the statement is wrong, or the Lordship constitution should be Lordship. Something is there, Lordship.
All right.
So Lordship, and Lordship, I have ended over.
I am not reserving it today.
Lordship, examining even Lordship may posted after vacation also for further.
Correct.
Yes, because in this case, Lordship, something has
Let me have a look at it.
Lordship.
Mr. K. Gogoi, Learned Counsel, Learned Standing Counsel CGC, on behalf of respondent number 1, 2, 5, and 6, has submitted written synopsis in the matter. Stop. List this matter after vacation.
Lordship, in the last part of October, then Lordship has some time will Lordship.
29th?
29, Lordship.
List this matter on 29/10/2024 for further hearing.
Lordship.
I am only saying further hearing.
Yes, because Lordship have to examine everything.
Correct. After that, in case something comes, because things are still not clear.
Lordship.
So I might need some clarification. So
Otherwise,
let me have a look at it.
Lordship.
Yes.
I am appearing on behalf of respondent 7.
The institute.
After receiving the impugn order, I issued the order, one order dated 24/7/2024, requiring him to submit, requiring the petitioner to submit his service records. That is why they implemented me as a respondent number 7. I adopt all the submission of Mr. Kushraf Gogoi. So far as it is borne by the substantiated by the record.
Your name is?
Substantiated by the record.
Your name is?
A.K. Datta.
Mr. A.K. Datta, Learned Counsel for the newly implemented respondent number
7,
adopts the arguments of Mr. K. Gogoi, Learned CGC.
So far
I'm
as
just keeping that
so far as the
yes.
Submission.
Yes, because the future of the institute depend upon my lord's decision also. Yes, because so Lordship said to examine everything.
Mr. Drupat, Mr. Das, I am keeping this matter. I'm not yet closing it because a lot of materials have been given. So I will have a look at it and I'm posted it on 29th.
Lordship.
I'll inform the Lordship.
For orders, item 30.
Yes, Mr. Chalia.
Lordship, here the order has been complied with, Lordship. If Lordship.
Any affidavit filed to that extent?
Lordship, here the difficulty is there is only one contemptor and that person has retired and this post is no longer. So
is it complied?
Your Lordship, the engaged counsel is having some personal difficulties.
Where is the order, Mr. Chalia?
Lordship, allow me. Lordship, the operative part is in page 14, paragraph 11. Page 14, paragraph 11, Lordship.
Yes. Yes, please read.
Yes, having heard learned counsel for the parties on perusal of the material, including order dated so and so, court is of the view that the speaking order passed by the Director of Health Services dated so and so may not be that the final word in the matter. In view of the communication of the director himself dated so and so, it is necessary that the department authorities should verify the claim of the petitioner afresh with following rejection of the same by the director. To ensure a fair verification, court is of the view that the additional chief secretary to the government of Assam in charge of health and family welfare department should constitute a 3-member committee to look into the above aspect of the matter. The members of the committee should be officers above the rank of director. Let the committee be constituted within a period of 4 weeks from the date of receipt of the certified copy of the order. The committee shall examine the claim of the petitioner in light of the departmental record and thereafter pass appropriate orders.
So committee has been constituted.
Yes, Lordship, I have the report. If Lordship,
Committee has examined the case of
yes,
the
Lordship,
petitioner.
and there.
Has the petitioner been given opportunity
Yes,
of hearing?
Lordship. Here the report is with me, Lordship. If I can just. Lordship, first page, Lordship, second last paragraph, Lordship.
Yes.
DHS collected and submitted detailed reports from all districts. Upon examination of these reports, were found that there was no instances of male village health guides having worked between 1786 to 31/3/2002. Based on the comprehensive review of district reports provided.
No, this is one part.
Yes, sir.
But from where you can show that the committee, as required under para 11, has been constituted.
Lordship, on the very next page, Lordship, the.
Yes. And these are all above director.
Yes, Lordship. The
So
secretary.
this is because if we read para 11, I think first part requires constituting of a committee.
Yes, Lordship.
So this 29 February is the constitution of the committee.
Yes, Lordship.
Correct.
Yes.
Now, second part is before notice has to be given.
Lordship, here.
Where is that?
Lordship, here in the report, Lordship, in the instruction.
Yes.
In the second paragraph, Lordship,
Yes.
the committee instructed the director to collect and submit consolidated reports from all districts regarding the employment status of male village health guides. Lordship is basically payment of honorarium to the village health. A hearing was also called for.
Where you are reading?
Lordship, the second
paragraph. Yes.
So basically, payment of honorarium to the village health guides if they are entitled to. So, Lordship, third line, a hearing was also called on 03/04/2024 involving the secretary and other officials of Sadar to obtain
03 or 08?
08, Lordship. I apologize, Lordship. Involving the secretary and other officials of Sadar Assam Jana Rakshak Santha to obtain clarification regarding their services and supporting documentation that might help to prove their claims. During the hearing, members of Sadar Assam Jana admitted that they had no proof or evidence of working as village head during
So this petitioner is a member of the Sadhu Assam.
Yes, Lordship, it's the committee only who has filed it, Lordship.
The Sadhu Assam. So
Yes,
they were
Lordship.
there.
Yes, Lordship.
So nothing survives. It has been done. I'm closing it. Yes. This is item 40.
Lordship, 30.
30. Heard Mr. A. Chalia, Learned Counsel. Sorry. Heard MS.
P. Roy.
Huh?
P. Roy.
P. Roy, Learned Counsel, appearing on behalf of
S. Nazneen.
Mr.
Ms. S. Nazneen.
MSS Najneen, Learned Counsel for the petitioner. Stop. Also heard Mr.
Lordship, I've been asked to assist the court, so Lordship may record my name for the health department because officially I'm the court, honorable court had asked me to assist the court on this.
By which order?
Lordship, the order. Lordship.
Yes.
Maybe 1/4/2022, Lordship.
Also heard Mr. A. Chalia, Learned Counsel, appearing on behalf of the health department.
Lordship.
But you please give me that order because I want to put it.
Yes, Lordship. I just have to check, Lordship. I think, Lordship, the order was passed by Honorable Justice Devashish Barua, Lordship. I'll just check the order, Lordship.
You try and give me that order.
Yes, Lordship.
Because anyway, by way of this contempt petition, under Article 15 of the Contempt of Courts Act, read with Article 215 of the Constitution of India, comma, the petitioner has drawn the attention of this court to the alleged willful and deliberate violation of order dated 26/2016, passed by this honorable court in WPC number 847 of 2014. Stop. In view of the submission of the Learned Standing Council Health Department on 6/10/2023, this court adjourned the matter to enable the Health Department to apprise the court as regard the progress of the hearings before the committee. Stop. It is in view of the submission of Mr. So-and-so to the effect that committee of 3 members has been constituted and they are examining the individual claims of the writ petitioners, including the contempt petitioners. It further appears that when this matter was listed thereafter on 29/1/2024, a submission was made on behalf of Health Department that the 3 members committee has already submitted a report which is being considered, which is under consideration before the government in the Health Department. Stop. Today, when the matter is called, Mr. H. Alia, Learned Standing Council, Health and Family Welfare Department, places the letter dated 30/5/2024 issued by the Joint Secretary to the Government of Assam, Health and Family Welfare Department, whereby it is informed that the committee has examined the case of the petitioners, including the contempt petitioner, after duly hearing the petitioners and has passed the appropriate order. Stop. Correct.
So, wide order dated 1/4/2022.
What is and pass the appropriate order by what?
No, Lordship, the Honorable Court had requested us to assist the court-wide order dated 1/4/2022.
1/4/2022. Before proceeding further, apt that by order dated 1/4/2022, this court, this court requested
Mr. B. Gogoi, Lordship.
Mr. B. Gogoi, Standing Council, Health Department, to assist this court. Stop. By operating paragraph of the judgment and order dated 26/2/2016, passed in WPC number 847 of 2014, against which this contempt petition has been filed, is reproduced hereunder for ready reference. quote unquote paragraph 11, page 14. Apparent reading of the aforesaid paragraph that this court had directed the respondents firstly to constitute a 3-member committee to look into the claims of the petitioners afresh and examine the same in the light of the departmental record within a period of 6 months, after giving due opportunity of hearing to the representatives of the petitioner society. Stop. A reading of the aforesaid, instruction dated 30/5/2024.
Lordship.
Apparent that a 3-member committee was constituted by notification dated 29/2/2024, consisting of the Secretary, Health and FW Department as the chairman, Additional Secretary, Health and FW Department as member, and Joint Secretary, Health and FW Department as member secretary. Stop. A copy of relevant portion of the notification dated 29/2/2024 is reproduced hereunder for ready reference. B2B to A flag to paba, huh? Pink flag. B will do this. Thus, the aforesaid constitution is in terms of paragraph 11 of the said judgment, which mandated that the members of the committee should be officers above the rank of the director. So, which is the order is, what are these statement recorded and all that?
Lordship, these are basically the reports.
Reports.
That is, Lordship, the report has been placed here.
Thereafter, it appears that the 3 members committee had examined the claim of the petitioner, wherein the members of the petitioner association was present, and after duly hearing, the committee submitted its report, which after examination by the government of Assam was found that there was no instances of male village health guides having worked between 1/7/1986 and 31/3/2022. Stop. Be that as it may, it appears that the order of this court dated 26/2/2016 has been complied by the respondent authorities. That being so, nothing survives for adjudication in the instant contempt petition. Accordingly, the contempt petition stands closed, disposed of. A copy of the letter dated 35/2024, instruction dated 35/2024, along with the enclosures, is kept on record and marked as X. Disposed of. Yes.
Already complied.
Complied? 32, Pallavi. Heard, Mr.
HR Ahmed.
HR Ahmed, Learned Counsel for the petitioner. Anybody? Other side? No.
No.
By filing this application under Section 11 and 12 of the Contempt of Court Act 1971, read with Article 215 of the Constitution of India, the petitioner draws the attention of this court to the alleged willful disobedience and deliberate violation of the Common Order dated 7/6/2022, passed in WPC number 1688 of 2021. Stop. Mr. So-and-so, Learned Counsel for the petitioner, submits that in the meantime, the order of this court dated 7/6/2022 has been complied by the respondents. Stop. In view of the aforesaid endorsement made by the learned counsel for the petitioner, nothing survives for adjudication in the instant contempt petition. Accordingly, the contempt petition stands closed.
Obliged.
Yes, Mr. Borguia.
Property part of the order is at page 27.
Yes, Mr. Chalia. What about affidavits?
Yes, Lordship, here, Lordship, we require some time to comply with the court's order, Lordship. Here,
This court is not an executing court, Mr. Chalia.
Lordship, here, we have to finalize the pension paper of the petitioner's Lordship. For
This
that,
court is not concerned about your what you have to do and not to do. You one time you could have filed an extension application.
Lordship,
They
here.
can, the sitting silent will not absolve the officer.
No, Lordship, here.
These court orders has to be respected. in
Lordship,
good
here.
spirit.
Yes, Lordship, in my humble, I just required, we need some.
All right,
time
I'm giving you time, but I'm making it very clear. As prayed for, list this as prayed for by Mr. A. Chalia, learned counsel for the respondent, list this matter after 2 weeks to enable the respondent to file
I'll file my affidavit.
their affidavit in opposition in the matter.
Before.
Yes, Mr. Bob. Yes.
My lord, here, my lord, I am sitting some time, my lord, to file an affidavit, my lord, on behalf of
As
R2.
prayed for by Mr. R. Borpujari, learned counsel for respondent number.
Both the respondents, R1 has already filed an affidavit.
For
R2, I
respondent
will be
number
filing.
2,
My lord.
which is not opposed by the other side, list this matter after 2 weeks to enable the said respondent to file return in the matter.
I'm so obliged, man.
Yes. Are you there? This is a matter of Mr. M.K. Chaudhary.
Yes.
Come. 36.
36. Yes, Your Lordship.
Yes, who's appearing in the other side? Service is not complete, I think, right?
No, steps have been taken, Your Lordship. We're not privy to the office note, but
No, it says unserved notice has been placed on record.
then we might be required to take further steps
You take
based on new
fresh
instructions.
steps?
Yes, because the incumbent might have changed. So that's a possibility also.
As prayed for by Mr. P. Sharma.
M. Sharma.
Mr. M. Sharma, learned counsel for the petitioner, list this matter after 2 weeks to take fresh steps if required.
Yes, I'm grateful, Your Lordship. 37.
You examine and see if required. Check
Yes.
that flag.
We'll do that. We'll do that. Just grateful, Your Lordship.
May I please, Your Lordship? Lordship, in this matter, I need some 2 weeks more, my lord.
As prayed for by Mr. S. Datta, learned counsel, appearing on behalf of respondent number 2, list this matter after 3 weeks on a date to be fixed by the registry to enable the respondent to file return in the matter.
My lord, this is my lord 2022.
24?
2022 judgment. my
All
lord.
right, let them file it. You file it. It is needless to be clarified that if the affidavit as required is not filed by the next date of listing, this contempt petition shall be proceeded in accordance with law.
My lord, I want to inform the court, my lord. Respondent number 2, my lord, already transferred in the last month, my lord. I will file affidavit, my lord.
You file, you see, I do not understand why you people keep on insisting that some officer has been transferred.
I'm just
The incumbent at that relevant point of time does not get absolved merely because he's been transferred out.
I'm just
Anyway, you give that information to your friend.
Yes.
He will do the needful.
My lord.
You
I'm
do
just
the
trying to
needful
inform-
if a new incumbent has come. Otherwise, it will not get affected.
My lord.
Yes, next matter,
And
please.
other two respondents are, my lord, still there, my lord, in-
All right, next matter.
Highly obliged.
Please, Your Lordship. Lordship, the respondent number 3.
Where is the counterpart? Order 38.
38.
Yes. What do you want to say?
Lordship, the respondent number 3 has retired from the position of CGM HRA, Your Lordship.
So he is he should this
No,
court now absolve him?
No, Your Lordship.
Then
This was for
why?
As
What
per
is
the
your instruction otherwise? Why the order is not complied, or the order has been complied?
Lordship, as per the instruction, the order has been complied with. Your Lordship.
Complied. Mr. Counsel, has it been
I have
complied?
not received. Direction is very clear. My representation to be considered, or otherwise.
Yes. What is your instruction? Show.
Page 13.
Where is the operating part of the order, Mr. Counsel?
Page 13.
Page
13.
13.
Accordingly, the impinned order it is set aside first, and it is directed that a fresh decision be taken in terms of the order dated past in and determination made by the court in the present order. Petitioner has given liberty to file representation detailing his claim.
Just 1 second. You're reading it too fast. Paragraph 9. It starts from.
My lord, yes, 13. Page 13 is 9.
1 second. That being so, there is no nexus between the regular appointment and the contractual period. Further, in view of the order passed in so and so, respondent authorities are having a bounded duty to examine whether the petitioner is entitled for such incremental benefit. Such exercise has not been done. Accordingly, is set aside, directed that a fresh decision be taken in terms of the order dated so and so and determination made by so and so. Petitioner is given to file a fresh representation. Such determination be made within the period of 3 months. So your representation has to be disposed of.
Yes, considered and they will decide.
My lord may peruse the instructions that I have received.
Mr. Counsel, this indicates that it has been disposed of.
I have not received any copy. This is my. If they have any copy, give me. Then my lord, I will provide a copy.
No, you have a look at. I'll take this matter at 2 o'clock. You check if if it has been complied. I'll close it. Give him a copy. Recall this matter at 2 o'clock.
Got you. If I have
Yes. I'm giving you. If you are satisfied, I'll close it.
Yes.
Because it seems it has been done. This court is not going to go into the merit of the decision.
No, not matter. No order has been communicated to the petitioner.
Very well. Have a look at it.
Yes.
Item 41.
Yes.
None appears for the petitioner on call. Stop. Mr. R.R. Gogoi, Learned Counsel, Learned Standing Counsel, PHE is present. Stop. This matter was listed today under the orders column with the remark for dismissal within quotes in view of no representation on 17/12/2021 and the last date of listing I-30/9/2024. Stop. In view of the fact that despite relisting the matter with a remark within quotes for dismissal, comma, there being no representation on behalf of the petitioner when called, the writ petition stands dismissed for non-prosecution.
42.
Next. You're appearing. All right.
Lordship, we are no longer in this case, Lordship.
You are no longer.
Yes, Lordship.
Then where is the new set of counsel? Anyway, since you have entered appearance, I will list this matter for orders. But have you filed any application saying that you all are not, the brief has been taken? You please do something, because this matter cannot go on like this where nobody will appear. It's a 2020 matter. If the petitioner is not interested, I shall close this petition. Right? Please write. MS?
S.A. Khalifa.
So and so appears on behalf of the petitioner, and CKS Borwa, so and so. R3. This matter was listed today under the order column with a remark within quotes for dismissal in view of the fact that there was no representation on behalf of the petitioner when the matter was last called I-30/9/2024. Stop. Today, when the matter was called, MS so and so, Learned Counsel, appears and informs the court that the brief has been taken away from them by the petitioner and a new set of counsel has been engaged. Stop. Be it as it may, since MS so and so has appeared before this court, let this matter be listed for orders after 2 weeks on a date to be fixed by the registry, where stop. MS so and so may no, don't say so. Registry may inform the next date of listing to the petitioner. For all right, stop. List accordingly.
Item 43.
May I please, your Lordship? Lordship, Senior Counsel Mr. Kiran Choudhury is appearing. Maybe your Lordship can hear the matter at 2. Your Lordship.
You all are appearing in 43.
Yes.
What is this matter? So it has come for orders.
It has come forward.
Yes, why is it come for orders? What is there? Why the matter is for orders today, Mr. Counsel? You have a petitioner. The returnable date,
Yes.
Mr. Fukan?
Yes, there was I think they paid for an interim order that was not granted. And I believe now it has come up, we filed a Wakalatam and also a reply. He appears for the department directly for the respondent number 6.
When did you file your affidavit?
Today morning, and I got it mentioned that.
No, but this
We
matter
had
is for orders today.
It is for orders. I am for respondent 5.
Yes.
Lordship, if it may be taken to your Lordship, I have to.
True. But it is for orders. Matters cannot be heard in order column like this.
Obliged.
Are you awesome? 39 2.
For hearing, I did number 79.
Yes.
I pray that the matter may be discharged after vacation, Your Lordship.
All right. As prayed for by Mr.
MH Laskar.
MH Laskar, Learned Counsel for the petitioner, list this matter after 2 weeks on a date to be fixed by the registry. Lords. At our 30 go. Aisa? Yeah, Aisa.
My lord, as per the instruction I have received, there are two instructions. First of all, the order, the honorable court's order, that has been complied with, my lord.
Yes, I think it was written on the That's the matter. In the first time, you were not there.
Yes,
Someone
ma'am. I
else
was on
there.
legs on the other court. I apologize, ma'am.
Where is the counsel for the petitioner? I think there he is. Yes, did you check?
Yes, I have gone through it.
Complied?
Yes, ma'am.
All right, I'm closing it then. Please hand over the set of instructions.
Yes, ma'am.
To item number 38. Heard Miss Dr.
Yes, ma'am. Mr.
G.
Mr. S, ma'am.
G.J. Sharma.
Yes, ma'am. Mr. S, ma'am.
S. Nath.
Ma'am.
Sorry. Heard Mr. S. Nath for the Learned Counsel for the petitioner. Stop. Also heard Mr.
SP Sharma, ma'am.
SP Sharma, Learned Counsel for respondent numbers 1, 2.
All the
for the respondents, contemners. Respondents stroke contemners. Stop. By way of this petition, contempt petition, the petitioner is drawing attention of this court to the alleged non-compliance of the judgment and order dated 13/6/2023 passed by this honorable court in WPC number 2936 of 2013. Stop. Today, when the matter was called, Mr. So-and-so, Learned Counsel for the contemners, submits that the order of this court against which the contempt petition has been filed has been duly complied. And in support of the aforesaid submissions, he furnishes the instructions dated 10/9/2024 received from the Office of the Assistant General Manager within bracket law APDCL Guwahati. Stop. A copy of the said instruction is kept on record and marked as X. Apparent reading of the aforesaid instructions that the order of this court dated 13/6/2023 passed by this court in WPC 2936 of 2013 stands complied. Stop. As such, nothing survives for adjudication in the instant contempt petition. Stop. Accordingly, the contempt petition stands closed. Disposed of.
That being item.
May it please, Your Lordship.
Yes, Mr. Chaudhary.
Yes.
This matter is for orders.
We don't recollect, an order, a notice was issued for my termination, which will take effect from 10th of October. Having regard to that date, Lordship was pleased to fix the matter today. Now,
So this is
if the
that
Lordship
matter.
kindly comes to the impugn order, at page number
You are
90.
challenging the termination.
Yes. I'm a provisioner, madam.
Page number
90. In pursuance to the terms and conditions mentioned in the appointment letter referred to above, I hereby give notice to Dr. S. Rohit, presently serving on probation period, that his services shall stand terminated with effect from the date of expiry of a period of 1 month from the date on which this notice is served, or as the case may be, tendered to him. So, my lord, by this impugn notice, and 1 month notice has been given to the petitioner. So, it was issued on 11/9/24. So, it will, my lord, come into effect on 10th. Now, my lord will kindly come to page number 94.
Who's appearing
No,
for
first, my
Ames?
lord will kindly come to the appointment
Who's
order.
appearing for Ames Guwahati?
They filed a short affidavit also. my
You're
lord.
appearing.
Yes. If your lordship will kindly
And
come to
Mr. Fukan, you are for?
Respondent number 6.
Who's-
Respondent number 5.
Who's our respondent 5?
He is Professor Ashok Puranik. He is the director.
And R6? Huh?
Head of department.
Yes.
Otherwise, the main respondent would be Mr. Gogoi.
Lordship, Lordship.
No, main respondent is my lord, respondent number 5.
R5.
Yes. How can my learned friend be main respondent? He's Union of India. Please come to page 36,
I
my
am
lord.
representing director of the institute. Lordship.
All right, all right.
I believe Mokole. Anyway,
1 to 4, actually.
Direct,
1 to 4.
director by name they have implemented, so he is appearing on the by name. He is
Executive
appearing.
director who has issued this order.
Lordship,
Yes,
by name
That
he is.
is respondent number 4.
By name, perhaps, because they have
By
may
name,
have
that's
alleged
why
some
he is
malaf
appearing.
ID.
That's right.
That's why he is appearing.
Correct,
Otherwise,
Mr. Chaudhary.
Yes, my lord will kindly come to page 36.
Page 36.
In the impugn notice, my lord, they refer to the appointment order.
Yes,
Page 36, para 3.
yes.
Your appointment may be terminated at any time with a 3 months notice by either side. So, my lord, appointment order speaks of a 3 months notice or
But
pay
what is given to you is a 1 month.
1 month notice. And yeah, or in lieu thereof, they can give 3 months pay.
3 months pay.
Notice or pay, Mita?
That is not given to it. It is only a 1 month notice.
1 month notice.
So on the face of it, it looks it is in violation
Contrary to
of
the
this.
appointment order.
Contrary.
Yes, yes. Now, my lord will kindly come to page number 91.
But this court is only hearing you for interim.
Yes.
I'm not
I'll be
taking
very
it up.
precise. I'll just take 5 minutes.
No, I'm
time.
just indicating because it should not appear as if I'm taking it up a
Yes,
final discussion.
yes, yes, yes. Certainly. Please come to page 91, my lord.
Yes.
This is a Government of India order dated 26th of
5-1.
August 1967.
What is Rule 5.1?
Yes, Rule 5. This is the, my lord, under CCS temporary rules. It empowers the appointing authority to terminate these services by giving 3 months notice. Rule 5.1 not to be applied to provisioner. This is the Government of India decision which is binding on everybody, including respondents number 1 to 4. A question has arisen whether this rule should be invoked also in case of persons appointed on provision. Whether in the appointment letter a specific condition regarding termination of service without any notice during or at the end of the period of probation has been provided. The position is that CCS temporary service rule do not specifically exclude provisioner or person on probation as such. However, in view of this specific condition regarding termination of service without any notice during or at the end of the period of probation, it has been decided in the consultation with Ministry of Law that in cases where such a provision has been specifically made in the letter of
I've read
appointment.
it. It has to be in terms of the appointment.
Exactly.
Yes.
So 5(1) of the temporary service rule cannot be invoked. Now, my lord, I am a provisioner. Yes, if in the process of assessing my performance towards suitability, if some shortcomings are noticed, then my lord, my services can be terminated by following the procedure prescribed.
That reasons have not been given
Nothing.
in page 90.
No, yes. No, my lord will kindly come to page number 94.
But 90 also no reasons.
No
isn't it?
reason, nothing. Now
94.
please come to page 94. Now, even on the substantive provision, this is the Government of India circular. A provisioner who is not making satisfactory progress should be informed of his shortcomings well before the expiry of the original provisionary period, so that he can make special
Mr.
efforts.
Chaudhary, what is this document
My lord,
part
this,
of? Page
yes.
94.
This is OM dated 11th of March 2019, issued by Government of India, Ministry of Personnel.
This is part of this
Yes.
Annexure 20.
Yes.
Okay. Okay. Sorry, you may read, please.
Yes. A provisioner who is not making satisfactory progress should be informed of his shortcomings well before the expiry of the original provisionary period, so that he can make special effort at self-improvement. This can be done by giving a written warning to the effect that his general performance has not been as such as to justify his confirmation, and that unless he shows substantial improvement within a specified period, the question of discharging him would have to be considered. Even though this is not required by rules, discharge from service being a severe, final and irrevocable step, probationers should be given an opportunity before taking drastic
That is
steps
not
of discharge.
done.
That is not done.
So, basically twofold that you have argued for the interim relief. One is that the 3 months period
Not
is
in accordance
given.
with the appointment order.
And
Secondly,
second
this.
is that no opportunity was given.
And my lord, from the affidavit filed by respondent number 1 and 4,
Yes.
I'll establish, I need not file a reply. I'm obliged to them, my lord, for filing this affidavit, that they have themselves made out a case of, my lord, this order of termination being founded on some allegation.
Sure.
Yes. Now, my lord will kindly take the affidavit filed by respondent number 1 to 4. Please come to, my lord, para 26.
There is 1/5 also.
1/5 also.
All the respondents have filed their affidavits.
Yes.
Affidavits do not forthcome in pension matters, but in these matters, affidavit comes
Yes.
within
When it
2-3
matters,
days.
my lord, they can do. Please come to page 156.
Page?
Page 156, my lord.
Yes. This is the affidavit filed by the AIMS.
Sorry, my lord will kindly come to page 151, my lord. Para 12.
Page 151.
Yes. Well, I'll give a little background in this case, my lord.
Page 151 is some annexure.
No, my lord.
I think
151 is the part of the affidavit.
Perhaps I'm taking a wrong affidavit.
Yes, my lord will kindly take
which
the affidavit
are you
filed by
relying?
respondents 1 to 4.
This is, I've got 5, 6, and 1 by AIMS. There is a 4th affidavit also. 4 affidavits have been filed.
2 affidavits are for Dusty. One is for affidavit in opposition by AIM.
That I have got, and then I've got 1 of 5 and 1 of 6.
Yes. And
1 to 4 visible.
1 to 4 is also there. 6 they have filed right now.
But where is 1 to 4? 1 to 4.
It starts from also page 148.
Just have a look, please. I found 5, 6, and AIMS.
My lord, by the time I'll just point out one thing, my lord. My wife has been subjected to sexual harassment in workplace. My wife is also faculty. Now, my lord, the internal complaint committee submits a report saying that yes, it has taken place. Now, my lord, the management is protecting those people, my lord.
What is the stand of the respondent as regards the 3
Yes.
months notice and no reasons. Where is that stand in the affidavit?
Yes, I'll bring that.
Because I think I shall just confine to that as
Yes.
for the moment.
No, my lord,
because
one more point.
I am
Kindly
not going
permit
into
me.
the merit.
No, Lordship will kindly permit me one more point, just one paragraph. Please come to page 151.
No, from this affidavit, what?
Yes,
are you
para
referring?
12. One paragraph only.
Paragraph?
151, para 12.
It's not 151.
Yes. It starts at 148.
158 it is there.
No, 140.
No, in this copy, is this does it say that with regard to the statement made in paragraph 12 of the
Yes,
petition?
yes. That with regard to the statement made in para 12 of the writ petition, the deponent begs to state that this statement made in this paragraph are wrong and baseless, hence denied. The petitioner has taken a path of making false and malicious accusation against the superior authorities to create confusion and gain sympathy. The AIMS administration has followed due process and taken action as appropriate and deemed necessary while addressing all complaints and events as cited by the petitioner. All actions of the AIMS administration have been without any prejudice. Now kindly see, there was a discussion in the governing body and the institute body which was convened as an emergency meeting to consider the various aspects of complaints made by the petitioner and his spouse. My lord, we made the complaint and my lord, actions are taken against us, not against those against whom we filed the complaint. It would be pertinent to mention here that governing body and institute body are the top decision-making bodies with complete powers of appointment, termination, dismissal. Thereafter, opinion was sought from AIMS legal counsel appointed by central government. As such action taken, my lord, they don't say anything on merit. All that they say
Prima facie, I am of the opinion of staying the impugned order.
Yes.
Yes, Mr. Gogoi, anything you want to show?
Yes.
Come to page 36 of the writ petition.
Page?
My lord, with your lordship's kind permission, can I take leave? My friend would be there.
Page?
Page 36 of the writ petition.
Yes.
It starts from page 35, Lordship, the part of the Lordship, the appointment letter.
If you are otherwise found ineligible.
Lordship may kindly peruse serial number 3, the condition of appointment. Page 36, Lordship.
Page 36.
Page 36 of the writ petition, Lordship.
Yes, I have it.
Of the writ petition, Lordship.
See, yes, your appointment may be terminated.
Lordship, my lord, kindly peruse. Your appointment may be terminated at any time with a 3 months notice by either by this the appointing authority without assigning any reason whatsoever. That's a one part, Lordship. Then my lord may kindly peruse. It will be open to the institute to pay in lieu of the notice period by which the notice falls short, Lordship. It is not said that,
No,
Lordship.
but have you done that?
We have done, Lordship. Addendum is done, Lordship. And in that aspect, Lordship, I have the original records also as per Lordship's direction.
You have paid in lieu of the notice period.
Lordship, it is done.
On which date you have done?
Lordship?
On which date have you done?
It is on 19/9, Lordship.
And this
19 and
termination
petitioner
order is 11/9.
11/10.
11/9. And this pay thing is dated? Please give
After
me the
that,
date,
19/9,
Mr. Gogoi.
19/9. After filing of the case.
19/9. How can that be? 19/9.
19/9, Lordship. And that was
In
received.
addition to the 1 month, but this is not part of the 11/9/2024. You have subsequently done it.
But that part done, as because notices fall short, it was subsequently came to the knowledge of the authority. That's why that addendum was done, Lordship. It is a continuation of the termination order, Lordship. It is within the period, that period, Lordship. We are not, Lordship, across the
It is not
period.
about being continuous,
Lordship.
Mr. Gogoi. If a power is
Lordship.
given, the power has to be exercised in that manner or not. All
Lordship.
other matters would be forbidden.
Lordship.
It is clear.
It
3
is
months or in lieu.
3 months.
Now it appears on 11/9 you have given 1
11/9
month.
admittedly-
It falls short of 2 months, and then subsequently after the writ petition has filed, you have done this.
Lordship,
I am on the conduct, Mr. Gogoi. I am not on
No,
anything else right now.
I am understanding, Lordship.
Because you see, I am not hearing the matter today.
Lordship.
Finally, it may go this side, it may go that side. That is a different aspect. But for the purpose of interim order only, I'm hearing.
Lordship.
Prima facie looks something is wrong.
Lordship, may I kindly peruse page 104 also, Lordship.
Page 104 of?
104 of the repetition, Lordship. It's part of the Ministry of Health and Family Welfare.
What do you want to show from 104?
Lordship.
What do you want to show from 104?
104 is the act of the aims, Lordship.
What do you want to show?
Lordship, regarding period of
No,
probation.
clause.
So, Lordship, may paragraph 100, page 100, Lordship. Page 100, it's a Ministry of Health
Then
and
I've
Family.
understood, Mr. Gogoi. From page 104, which clause do you want to
Clause
show?
25, my Clause 25, Lordship.
Please
Clause
read.
25. Unless otherwise decided by the appointing authority in any case, all employees shall be on probation for 2 years. During the period of probation, the employee shall be required to put in a satisfactory service, failing which his service shall be liable to be terminated at any time without any notice, Lordship. It is as per the statute, Lordship.
Which is the other clause just...
Other clause is in the appointment letter, Lordship.
No, one more clause, that page
It-
92,
it's
that
a,
office
it's a master
memorandum.
circular issued by the Lordship Ministry of Public and Pension.
That is not applicable?
Lordship.
No,
We are-
but
One
One second. Mr. Gogoi, please do not
Lordship, I am
use
sorry.
these languages in this court. This court is there.
Lordship. I apologize. Otherwise, Lordship, he
No,
should
please don't do all this.
He should not disturb.
I am
me.
here
Lordship.
to take notice of and do what is required to be done.
Lordship.
Otherwise, I'll go inside, you conduct the proceedings.
I apologize, Lordship. I apologize.
Yes.
It's a part of the statute, Lordship.
This is the part of the
Paragraph 25.
No. This paragraph, this page 94 document which was shown.
94.
This is part of some office memorandum.
It is a office memorandum issued by the Ministry
This
of
is not
Public.
applicable here.
Office memorandum cannot override the statutory prescription prescribed by the statute.
This is this at 104 is a
104 is a statutory prescription prescribed by the statute. It starts from page 100.
this is
Lordship.
also a notification.
It's a notification, Lordship, Ministry of Health and Family Welfare, All India Institute of Medical Sciences, Lordship. It's a act, Lordship, short title and commencement. My Lord, my
So
kindly
this
pay.
notification is issued under
This-
section 29 of the Act.
Lordship. This regulation may be called the All India Institute of Medical Science Regulation 2019, Lordship.
So this is a statutory
Statutory
instruction
regulation.
according to you because issued
Lordship.
under the
If we go
section
by the
29.
Lordship, the golden principles
And
of law, Lordship.
here it says during the period of probation, the employee shall be required to put in satisfactory
Lordship,
service,
Lordship.
failing which his service shall be liable to be terminated anytime so and so.
Lordship. If we go by the golden principle of law,
But
which is
Mr.
set out,
Gogoi,
Lordship,
see, the
Lordship.
difficulty that this court is feeling is that your termination order doesn't speak of anything.
Not
If-
required, Lordship.
No, what I am saying is that
Lordship.
even suppose,
Lordship.
assuming you have
Lordship.
certain reasons,
Lordship.
you want to terminate without reasons, fine. But the fact that his service is not satisfactory,
that will be
that is also
discernible.
not required.
That from the record, Lordship. That from the record. It's from the record, not from the order of termination, Lordship. Termination order, Lordship, as per the Lordship, National Highway Authority's case also should not disclose everything, Lordship. And
not
even-
everything,
Lordship.
but the fact that his service has not been satisfactory,
satisfactory.
that part he is entitled.
That part, Lordship, it will be discernible from the records, Lordship. Here, even, Lordship, the statutory prescription is said that, Lordship, at any time without any notice, reasons for, Lordship, assigning in the terms, that part also, Lordship. It is not a case that, Lordship, the Ames Authority has violated the statutory prescription
All right,
prescribed by
anything
the
else?
statute, Lordship. And it is
All
as
right,
per the
I've heard.
statute, Lordship.
Anything else?
And regarding, Lordship, today they are paying for interim order, Lordship. At this stage, Lordship, whether Lordships consider the interim order or not, Lordship. That part I am relying to judgment of the Honorable Appeals Court, and Lordship may consider that particular to judgment, Lordship.
Give.
Here I am relying paragraph.
Here, are they seeking is the final relief the same?
Lordship, if
What
Lordship
is
may
the-
stay
what
the
is the
order, then
prayer?
it will be amounts to final relief.
What
which
is
is
the
granted,
prayer?
Lordship.
My lord, my prayer is that the
1 second, Mr. Counsel.
I was
Has the protocols of submission before this court, is there some change that
No,
this court is not
I apologize.
aware of?
I apologize. I heard my lord. It was asking me, my lord. That is, I apologize.
Please take your seat.
My lord.
You will get a right to reply.
My lord.
Lordship,
Yes,
Interim period is page 33, Lordship.
Page?
Page 33, Lordship.
30?
33, Lordship. Pending dispose, Lordship,
1 second.
Lordship.
Yes.
Pending disposal of the rule, your Lordship may be pleased to stay / suspend the impending notice of termination dated so and all other consequential action, Lordship. It's amount to revive the Lordship, the same position, Lordship. So, Lordship, I'm relying that judgment, if Lordship permit, I can read the two
No,
paragraph.
you just indicate the paragraph.
Paragraph 5 and 6 is Lordship permit, I can read it, Lordship.
5 and 6.
5 and 6.
Okay. And which is the
5,
other
Lordship.
judgment?
In our view, the interim order granted by the High Court is staying the
That's all right, Mr. Gogoi. This
Lordship,
position is well known.
Lordship. And
Only
other
thing,
is Lordship.
it is contextual, so the court will have to examine.
Lordship.
The other judgment?
Other two judgment is there, Lordship. One is 2018-17 SCC
Give the
203,
citation.
Lordship.
You have a printout?
I have print. I'll provide the relevant.
They are
paragraph
on
also.
which point?
It's exactly similar.
Same point.
Exactly similar point, Lordship. Exactly similar point, Lordship. And it is not a case that, Lordship. The
So
aims of
here in this case, in the Uttar Pradesh case, what was the
same termination order.
Termination.
Termination order. Same termination order. Against
that was under challenge?
under challenge.
And interim order, anything was given by
Interim
the
order
High
was
Court?
granted, Lordship. Against that, Lordship, it was
Staying the termination.
staying the termination. That's the. If Lordship, a short.
All right, read.
Lordship. A short judgment, so I have read from the beginning, Lordship.
All right, read.
Leave granted, heard the learned counsel for the parties at length. This appeal is special leave is directed against the interim order dated 23/10/2018, passed by the division bench of the High Court of the Allahabad at Lucknow bench at Lucknow in a special appeal being on so and so, and interim order passed by the learned single judge of the High Court in the writ petition being WPC number so and so. A writ application has been filed by a respondent challenging the order of termination of their services before the High Court of Judiciary of Allahabad at Lucknow bench at Lucknow. By an interim order, a learned single judge of the High Court had stayed the order of the termination of the respondent. An appeal was carried out by the state of UP against the interim order before the division bench of the High Court, which, however, affirmed the interim order passed by the learned single judge in the pending writ application, but directed the learned single judge to dispose of the pending writ application at an early date. Feeling aggrieved, the state of UP has filed this appeal special leave petition, which on grant of leave was heard in presence of the learned counsel of the parties. Oh, Lordship, we have heard so and so, Lordship. Having heard the learned senior counsel for the parties, and after considering the impending orders as well as the nature of the relief claim in the writ petition by the respondents, we are of the view that the High Court had fallen in grave error in staying the order of termination during the pendency of the writ petition. 5, Lordship. In our view, the interim order granted by the High Court staying the order of termination could not be passed at the stage in view of the fact that if such relief is granted at this stage, the writ petition shall stand automatically allowed without permitting the parties to place their respective cases at the time of final hearing of the writ petition. In this case also, the appellant have not yet filed counter affidavit so and so. That being the position in the
Here, there is a difference.
Lordship. No, otherwise we have filed.
No, I am not saying this. It is just.
Lordship. We have filed, Lordship. Yes, because today's consideration for interim order. That today's for consideration of the interim order. That's why I am placing this judgment. And other 2018 judgment also followed same procedure, same thing, Lordship. And it is not a case that, Lordship, the authority of the AMS violated the statutory prescription prescribed by the statute. We have done according to the statute which was prescribed in 25.
I forgot the name. There was a case of termination of a probation, a very famous case of 1958. Is it some Dhingra? Huh? Dhingra, right? You have that citation.
Purushottam Lal Dhingra.
Huh, you have the citation?
Yes, ma'am.
Can you give it to my bench clerk? 58, correct?
Yes, ma'am. I'll just give the SEC citation.
Yes, please. Rupak Lulwana. That was a termination of probation.
Yes, my lord.
Right?
They may, if my lord allows me, my lord, that judgment clearly stated if there is a stigmatic.
Correct.
There is a stigmatic. Then the inquiry has to
Notice.
happen on 311.
Correct.
So my entire case.
So whether it's a termination simpliciter or
punitive.
Correct. You have a copy?
Lordship, another cases, Lordship.
Dhingra to le lo, sir. Yes, this is also same interim.
Same issue. Paragraph 8.
All right, this you have. No need to multiply. This
Lordship,
point
Lordship. Even
taken note of. If it's
18 also similar point was Lordship discussed by the Honorable Court, Lordship. Honorable Supreme Court, Lordship.
So in a case where a termination order is under challenge, what according to you could be an interim relief if the court comes to a prima facie finding that the termination order is not in accordance with law?
Lordship.
Then what should be the interim relief according to you? I'm asking you a question.
Lordship.
What
Then-
according to
then-
you
then-
would be an interim order in
then-
that situation?
Then, in my view, Lordship have to fix the matter in an early date to dispose of it.
Is it?
Dispose of that, Lordship. That Lordship, the balance will be Lordship there. If that person's
Either that or the court can dispose of the matter also
Lordship.
on the day
The
one
court can dispose of the matter also
when
in
the pleadings are completed.
pleadings are completed while hearing the interim stage also. Otherwise, Lordship, if Lordship after hearing the parties, ultimately Lordship, if it in favor of the petitioner, then nothing will happen. If it goes against the Lordship petitioner, then Lordship the money which is from public exchequer, the taxpayers' money and other things, he even Lordship not for a minute also he cannot hold the office that particular post. Lordship.
He cannot.
He cannot hold the particular post. If Lordship
He cannot.
he cannot hold the particular post, Lordship. If Lordship decided against the petitioner.
See, I am not sure what I am going to decide. As of now, I am of the view that I am taking it up only for the purpose of considering whether an interim relief can be given or not given. This is the only opinion. But one thing which is weighing heavily in this court, why I am expressing it to you is so that you can get an opportunity of clarifying, is that it appears that on basis of certain allegations, the step was done. And it also appears that your stand is that he was not satisfactorily doing his duties. All right. As per the rules, as statutory regulation, you may not cite the reasons. But there is also an OM which says that if one probationer is not satisfactory serving, he may be given opportunities to improve. Correct? Now, these are, so those things also appears was never done.
Otherwise, Lordship, the record speaks that, Lordship. Two board meeting was.
I will hear you. Let him finish.
Two board meeting is there, Lordship, and even Lordship, the statutory provisions which is prescribed by the statutes cannot override by the.
That I've understood, Mr. Gogoi. But I don't think it is about overriding because the statute doesn't say that there will not be any opportunities given to improve the service. That it doesn't say. It only talks about the final termination. Correct. Now, by the OM says about the intergum period. It talks about the intergum period. I can read both together and say the boat can stand the field. That is one perception. I am not deciding it. But I am indicating that that could be a perception also.
At this stage, Lordship may hear the matter finally and dispose of the matter at the early stage, Lordship. Otherwise, Lordship.
All right.
Lordship.
Yes. Who is respondent? You are
number 5.
In person. Your name. But at this stage, I don't think I am not going into the malified aspect. So
I seek indulgence just
now. You see, if you seek too much of indulgence, then this court is going to hold otherwise, because you are in person, and the AIMS has already given their submissions. You've been made a arrayed respondent in name only because perhaps some malafide has been alleged against you. Correct, Mr. Counsel?
Yes, ma'am.
That is why he has been arrayed
Yes,
in name. Now, for consideration of interim relief, I need not go into those allegations. Correct. So, if this court is not going, your eagerness of addressing this court.
Lordship, I would
Yes.
still seek
What
your
do you want to
indulgence
say?
for 5 minutes. Lordship, I am representing respondent number 5 in the personal capacity. I would like to make the following observations. I am presently the executive director, AIMS, and whatever action I have taken is on an official capacity.
On an
official capacity, with due application of mind and following due procedure. I feel I have done nothing wrong and I take responsibility for my actions. Therefore, I find that the intention of impleading me in person as respondent number 5, when I have been impleaded as appointment in respondent number 4, is malicious. And it is with an aim to derail.
All right, Mr. Counsel, this
So
is
that is
something
one.
which is beyond merit. Yes, Mr. Fukan, you are appearing for whom?
Lordship, I'll just take 1 minute.
On you for interim
I'll
relief.
take
You
one.
want to say something?
Yes.
Opposing the interim relief, please say it. Otherwise, don't go into merit. These are not aspects that I'm deciding right now. So please do not
Lordship.
waste the judicial time of this court.
Lordship, I come to page 41.
Page
41. There are para 2 and para 3.
41.
41.
Yes.
During the para 2 and para 3 are mutually exclusive. My point of submission is that para 2 and para 3 are mutually exclusive. Para 2, during the period of probation, it is on the basis of your performance found unsuitable.
Para 2, just read it. Oh, all right. A. On the basis of your performance.
Or conduct. You are found unsuitable for further retention in service.
All right. According to you, 2 and 3 are,
Two are
distinct.
Distinct. They are exclusive.
If one wants to exercise powers under 3,
Not necessarily that it has to be.
All right.
So that was a limited point which I.
Okay, fine. Appreciate it. Yes. Mr. Fukan, only for interim. Who are you? Come this side.
Yes, I am the head of department. And
HOD.
and the entire allegation revolves around me because I have been considered to be the blue-eyed boy of the department who everybody is trying to
You
say.
are respondent?
6.
Oh, you are also in person.
Yes, I have also been made in person.
You are
for
HOD?
Yes. No role to play in the termination. I have nothing to say in regards to the termination. I keep myself very confined. This is a hospital. The entire actions revolve around certain doctors who are performing their responsibilities and obligation. I don't know ultimately whether your lordships will grant an order or not. I have 2 requests. The entire petition has been drafted in one very important paragraph at page 21, para 19. I just read one line.
Yes.
Page 21, para 19. This is 4 or 5 lines from the bottom.
Yes.
Therefore, the foundation on which this termination has been issued has a direct nexus on the sexual harassment case. Now that's me. If today the court decides that
You are the wife.
I am the doctor who against which the allegation of sexual harassment has been made. It is his wife who's the complainant in that case. Now the entire subject matter is also sub judice before this honorable court. There is a writ petition filed and the court is going to decide on that merit. If your lordships are keen on deciding, 2 things has to be considered. Today he is on a probation period. 10th he completes his probation. Then after that, when order is passed, he'll become a regular employee. The entire case becomes infractious. Because then that period has to be kept in mind and your lordships have to decide that no, we will keep this period within 10th. He cannot exceed. So if at all an order is passed, he doesn't become a regular employee tomorrow because the case is a probationer's case. It's not been regularized yet.
Sorry, I have not understood. You are
On 10th,
is it that you are trying to say that assuming this court grants an interim
order,
that
the period
should
of
not
service
extend the
period of service
period of
because then
service.
he becomes a regular.
No, in that case, this court will say will allow him in terms of the appointment when
Yes,
that expires.
because
it will
he's
expire.
not completed 2 years' time yet.
When will he complete?
The 10th.
Correct. So this cannot be an extension of that period. How can by
If that
way
is
of
kept in
interim-
mind, I have no problems. Number 2, this is a department which deals with a very specialized area of small kids from growth to 25 days. You know, they come through a lot of problems then when they come to this neonatology department that they are talking about. If at all an interim order is passed, it should be considered that the services of the doctors should not be hampered. Now, today he has now from one department has said, because there's no merger, I'm not been able to work in this department. That functioning should not be hampered. I am as a head of department, I'm working.
Mr. Fukan, how can this court go to
No,
that?
I tell you why,
But as
because
far the
I
first
have
is
limited
concerned, if at all this court considers granting interim, it would be subject to the terms and condition of
I
the
am only
appointment
requesting
order.
that the service
You-
is being cleared.
No,
That's all.
the first thing you want, that interim order should be subject to the terms and condition of the appointment order, correct?
Yes, because that is, he has to complete the.
That
period.
is that in case
And
if the
I have
code goes,
anyway
that
limited
is
people
all
in my
right.
department.
That is all right. But this,
Because
the
otherwise-
second part, what are you saying?
No, that's because.
Yes, Mr. Sharma has come to help you.
No, the services that have been defined, he has to come and perform the duties which are assigned by the department. That has to continue.
No,
because I, as an
this is-
HOP,
sorry, Mr. Fukan, I'm not being able to appreciate this argument of yours.
his termination is because there are certain things that I have raised in regards to his the function.
Okay.
Now, if that is taken into consideration to say that, well, he's not performing today, that should be considered when I'm giving an assignment to him tomorrow. Today, if there is a stay, it doesn't mean that he will not come and perform the duties which are otherwise attached to him.
So are you trying to say that if an interim order is given to the effect of allowing him till his term, then in that period, he should be
able to perform the duties?
That would be subject to that he performs the assigned duties.
Exactly. Whatever duties are
This
assigned.
is what
that's
you
what
are
I'm saying.
saying,
Yes,
that it is
as a head
assigned
of
duties.
department, that is my duty.
Assigned duties.
Assigned duties. That's what I'm saying. That assigned duties should continue. Otherwise, the patients will suffer. That is all my saying.
Okay,
in
Mr.
regards
Fukan.
to termination, I have nothing much to say.
Fair enough. Sharma, right?
Yes, my lord.
Mr. Sharma, this Dhingra's case, which is the paragraph?
My lord, paragraph, my lord, I have given the judgment.
Yes, I've got it.
My lord, if I have the liberty to just look at your judgment, I can just point it out.
Lordship, there's a small correction. He has completed 1 year out of the 2-year probation period.
Sorry.
He had mentioned 1 year that he is completing on 10. Actually, it is a 2-year probation period, out of which he has completed one. 1 more year is.
One more year is
Just to
there.
go. That is.
Only that 10th date is his 1 month notice.
Notice. That is 1 month notice.
So 1 year is still there.
1 year.
1 year. is still there. Mr. Gugud, which is the second case that you had given for? Okay.
Paragraph 8.
Paragraph?
Paragraph 8.
Mr. Sharma, if this court takes up this case for final disposal, do you have any objection? Because you have not filed rejoinder till now.
My lord, may I just submit before my lord? My lord, if my lord, what has happened as per the, my lord, in the interim, my lord, by the affidavit, my lord can draw the attention. Both the judgment which my lord, they have the UP and all. They both stated that if the affidavit has been filed, then the lords can make up the mind. So my lord.
So that is why if this court is applying its mind and
Yes.
ultimately this court assuming, not admitting that returns it in favor of you,
Yes, my lord.
then your rejoinder will not be required at this stage.
No, my lord.
Only if this court does not allow,
my lord.
Then of course this court will.
Absolutely, my lord. My lord, if my lord permit, my lord, I would like to show you para 16.
Para
16.
16 of which
of the affidavit filed by the Ames.
16.
Yes, my lord.
Yes.
The matter related to section. May I read, my lord?
Yes.
The matter related to sexual harassment of his spouse is being repeatedly brought in to divert the attention of this honorable court to the core issue that the petitioner was found unsuitable for confirmation while on probation on the merits of performance and due process has been followed. So the entire base on which my termination has been taken is because I have not performed. So moment you say I do not perform, a stigma gets attached to me.
Because tomorrow, when I'll apply in another AIMS or another institute, they would ask me the question that why were you not allowed to complete your probation? And that is why, my lord, the circular of probation that was been brought in by the master circular, it applies to all the union departments, which says a probationer should get the chance to explain his situation,
get a chance to improve
his thing. Now, my lord, the regulation which they have said they have followed, my lord, I would like to take the writ petition, my lord. And my lord, at last 117, my lord, there is a appointing authority, disciplinary authority, and appellate authority. 117, my lord.
See, without going too much into the matter,
I understand.
I am thinking of disposing it off in this way. Prima facie, I am of the opinion that that OM and that statutory regulation can stand together. As per that OM, if the department is of the opinion that the service of the probationer is not satisfactory, an opportunity can be given. If he still does not perform, he can be terminated without notice. Now, this can always be done. I will keep that open. I will simply say, in this case, it appears without giving any opportunity, directly a termination has been done. This court doesn't seem to me very right. So I will just hold that and I will send it back. You do whatever is to be done in accordance with law. I don't find any reason for keeping this matter pending. I'm not addressing the other issues. I'm not going into allegations and all that.
I absolutely...
Mr. Sharma, an order has been given in your favor. Otherwise, I will simply post it after vacation. No interim orders.
My lord, may hear me once, my lord.
I've heard. I'm giving an order in your favor. No. What more do you want?
My lord, what will happen? I'll just say
Mr. Sharma, I am giving you an order in your favor. Take it, or otherwise I am...
My lord, may just hear me once, so that if I can satisfy my lord, for the precious time, I will not waste of judicial.
You see, at this stage, nothing more.
I understand, my lord. But my lord, the way, my lord, what is fallen from my word, my lord, that has to be gone through the 117. My lord, that's a regulation, because they are relying on the regulation.
Yes.
I'm not...
So I'll say in accordance with law, whatever they will do,
Yes, my lord.
Then...
I absolutely understand, my
yes,
lord.
but I'm not going to lay down the law right now.
Absolutely, I understand, my lord. I'm not on that, my lord. This is what, my lord. This is 117, my lord. May see. Now, this is, my lord, see the appointing authority, the disciplinary authority, and the appellate authority for the various posts in the institute. My lord may see. Now, my lord may see Group 1 is a Group A post, director.
Yes.
Now, my lord may see other post, and just below that, other post. Appointing authority is the governing body. And disciplinary authority is the governing body and the president. And my lord may see penalties. All penalties 1 to 4 will be taken by the disciplinary authority. And the appellate authority will be the institute governing body. My lord, it's clear, my lord. Now, my lord, at 118, I'll just take 2 minutes, my lord, just to make the what is been going on. 118, my lord.
You are risking the change of the mind of this court.
My lord, I'll just take 2 minutes.
I'm telling you.
2 minutes, my lord. I'll just take 2 minutes. I understand, my lord. It's a
authorization. Take the risk.
My lord.
You go ahead.
My lord, the governing board, my lord. Now, my lord, may just 2 minutes, my lord, please, my lord, because we won't get the opportunity, my lord, because any order would be passed.
Yes, yes.
My lord, the note 118, my lord. The notice, the charge sheet, and the statement allegation shall be signed by the director on behalf of the governing body or the president, as the case may be, and documents shall expressly state the fact by order of the governing body or the president, approval of the governing body or the president. My lord, the notice did not contain anything. Now, my lord may see the stance of respondent number 5 and why I have made him a party by his name. He has himself admitted in his own affidavit at para 23, the deponent submits the notice of termination has been issued to the petitioner by respondent number 5 with due approval of the appointing authority. That means he has done post ifto, not is perfecto. It should be after. And how can the respondent number 5, if being an executive director does not have the power, can place something in the disciplinary authority and say, you act upon it?
All right.
So my lord, if my lord passes this order, so my lord, I may be protected from this action. That is all.
Protected from which action?
That the action should be as per this man. That is what
I have already indicated
My lord.
that they are at liberty to proceed in accordance with law.
My lord.
What more clarity do you
My lord,
need?
my lord. Absolutely, my. I bow down. my lord.
Just I clarify one thing. Just what?
Mr. Gogoi, you don't have to react to that. I'm not entering into that part.
He have pointed out lordship something.
Let him
which
point out,
which
Mr.
is not
Gogoi, this
applicable
court
to
is
his
not
case.
going into the merit
Lordship,
of the
lordship.
case. If this court goes into the merit of the case, either side one might get prejudiced.
Lordship.
Why should this court go into the merit? If the petitioner wants a final disposal on merit, then I will simply post it after vacation. Otherwise, I'm disposing of this case with the direction that that termination order appears to be not in accordance with law, and I will give liberty.
My lord, they will just correct it and send it again.
Mr. Counsel?
Absolutely.
Heard Mr. K.N. Chaudhary, learned senior counsel, assisted by Mr. S.P. Sharma, learned counsel for the petitioner. Stop. Also heard Mr. K. Gogoi, learned CGC.
Lordship.
For respondent number
1, 2, and 3, lordship.
1, 2, and 3.
1, 2, 3, and 4, lordship.
1, 2, 3, and 4.
lordship.
That means 1 to 4.
1 to 4. lordship.
Mr.
D.S. Bhattacharya.
D.S.
Bhattacharya.
Bhattacharya. You are from this court. Learned counsel appearing for respondent number 5. Mr. R. Fukan, learned counsel for respondent number 6. Anybody else?
Mr. Saikia.
You are there? Mr. S.K. Saikia for?
Respondent is with me.
You are a senior counsel?
No.
Neliki Bhatt. By way of this petition under Article 226 of the Constitution of India, the petitioner is assailing the termination order dated 11/9/2024 passed by the respondent number 7. Stop. The facts of the case is that Mr. Sharma, please find out that paragraph from Dhingra. No, just keep that ready. The facts of the case is that the petitioner, who is presently serving as assistant professor in the Department of Neonatology in AIMS, AIIMS in capital D, Guwahati, was terminated from service by order dated 11/9/2024 without any notice or reasons whatsoever. It is the specific case of the petitioner that the termination order is in clear violation of the terms and conditions of the appointment letter dated 22/7/2023. It is the further case of the petitioner that the notice of termination has been issued to harm the petitioner's reputation, and as because the wife of the petitioner is a victim of sexual harassment by respondent number 6, which has been established by the ICC report dated 17/2/2024. It is the further specific case of the petitioner that the impugned notice has been issued to protect respondent number 6 because the termination of the petitioner would automatically lead to closure of the sexual harassment case of the petitioner's wife. Stop. Mr. K.N. Chaudhary, learned senior counsel, submits that the termination notice, not termination notice, the termination order dated 11/9/2024 with 1 month notice period is in violation of the terms and appointment of the terms and condition of the appointment order dated 22/7/2023, whereby the petitioner was appointed to the post of assistant professor in level 12 of pay metric as per the 7th CPM minimum pay of rupees 1,01,500 plus other allowances as admissible on regular basis in the Department of Neonatology at AIMS Guwahati on probation. Correct? On probation. Wherein at clause 6, at clause 3, it was specifically prescribed that the said termination, that said appointment the said appointment is subject to termination at any time with a 3 months notice in lieu of notice period, and to pay in lieu of notice period by which the notice falls short.
28 paragraph.
Stop. He further submits that in terms of the where is that office memorandum?
Page 90, my lord.
Page 92. In terms of the OM dated 11/3/2019, it is imperative for the respondent to inform the probationer of his shortcomings, if any, well before the expiry of the original probationary period, so that he can get an opportunity for self-improvement. Stop. Mr. So-and-so accordingly submits that the termination order being issued without giving the requisite 3 months notice period and without giving any opportunity to improve the shortcomings as mandated under the aforesaid office memorandum, comma, is totally erroneous. Stop. Per contra, Mr. Gogoi so-and-so submits that under section 29 of 29 within bracket 1, 29(1) of All India Institute of Medical Sciences Act 1956.
With 25 also. 25. Page 104 also.
Failing satisfactory service of the probationer, the authorities at any time without any notice or reason being assigned can terminate the service of the probationer. Stop. He further submits that the aforesaid regulation being issued the aforesaid regulation, this is a notification, I think.
It's a act, not regulation.
No, this notification is issued under this provision of the act.
Section 29 of the All India.
No, that notification is issued under this section.
Yes, lordship is correct.
Huh?
Yes,
Pranav, I think
it's a regulation also.
Yes, all right. No, on top. No, not that. He further submits that the All India Institute of Medical Sciences Regulations 2009.
Lost 19 verse.
framed under
Lordship.
under section so and so. It milai diba, tate lagai diba. That is the correct position.
Lordship.
He further submits that the said regulations being framed under the provisions of the statute, the same is statutory, and the same cannot be overridden by way of executive instructions. Stop. Mr. D.S. Bhattacharya, learned counsel for the respondent number 5, while adopting the arguments of Mr. K. Gogoi, further submits that despite the Executive Director Ames Guwahati having performed his duties in accordance with law, has been arraigned in person. Stop. Mr. R. Fukan, learned counsel for R4-6, submits that but your submissions were on the interim, right? Both. So what was the second submission? All right. Submits in all fairness that in the event the petitioner is allowed to continue his probation period, he should be directed to perform his assigned duties for the interest of the hospital. Stop. You want to add something?
May I be permitted? I had mentioned about para 2 and para 3 being mutually exclusive. Mutually exclusive.
Of that OM. Which is an OM?
But it's about he's talking about a contract.
Yes. Where is that? Page.
35
Yes, I've got it. He Bhattacharya submission. He further submits that clause 2 of the terms and conditions of the appointment order dated 22/7/2023, which mandates the appointing authority to give opportunity to improve the survey performances of the appointee stroke probationer, is distinct and separate from clause 3 of the set terms and conditions of the appointment order, whereby the appointing authority is given appointing authority is empowered to terminate the service of the appointee stroke probationer by giving 3 months notice period without assigning any reasons whatsoever, and it shall be open to the institute to pay in lieu of notice period, by which the notice falls short. Stop. I have given my prudent considerations to the arguments made by the learned counsels for the parties and have perused the available material available on record. Peruse the material available on record. Stop. Pertinent that though this case was fixed today for consideration of interim relief, in view of the fact that the respondents have filed their counter affidavits and with consent of all the contesting parties, the matter has been taken up for final disposal. Stop. Relevant portion of the appointing order dated 22/7/2023 is reproduced hereunder for ready reference. Page 41 at A to A. Okay. This is this document, and 41 has been typed up.
Page 41.
Because this is the same clause, I think, which Mr. Chaudhary had relied.
Yes, my lord.
It would be to power. page 35 or 2 আছে তারপরে যদি সুবিধা হয় page 35 or লবা but the entire thing do you have a soft version of this?
Yes, my lord, I have.
If you have a soft version you can give it to the
My lord.
court master পুরা করে দিব apparent reading of the aforesaid terms and conditions of the appointment that the petitioner was appointed on probation for a period of 2 months with effect from 22/7/2023, which shall expire on 22/7/23, 2 years. Expire on
25, my lord.
when date?
He joined on 1st of August.
No, this is from the date of appointment.
Yes, my lord.
The letter of appointment was given on 22nd. He joined on the 1st of August. So it will be for 2 years, 1st of August to
Or I had to kobo nalage to. From the date of appointment. And that during the third period of probation, the petitioner shall remain as a temporary employee and will be governed by the applicable service rules. And that he will be liable to be discharging, that he will be liable to be discharged from service at any time without any notice if on the basis of his performance or conduct he is found unsuitable for further retention in service, or if he otherwise is found ineligible or unsuitable for being retained in service. Stop. It further appears that under clause 3 of the aforesaid appointment order, his appointment as on probation is subject to termination at any time with a 3 months notice period without assigning any reason whatsoever. It further appears that it is open to the institute to pay in lieu of notice period by which the notice falls short. It appears that by order dated 11/9/2024, the petitioner was placed under termination by giving 1 month notice period, which expires on 10/10/2024. Stop. A copy of the said termination order is reproduced hereunder for ready reference. Page 90, B to B. The issue that arises for consideration in the present writ petition is the legality and validity of the termination order dated 11/9/2024. Stop.
Just I indicate lawsuit. Is lawsuit I can may indicate that addendum also lawsuit. The addendum part also lawsuit may indicate.
Sorry?
The addendum part also lawsuit may indicate.
Which addendum?
That in lieu of 3 months notice, 2 months payment was given. That part lawsuit may
Yes,
indicate.
I am dictating, Mr. Gogoi. If I don't take, if I do not address something which you want to tell me, why are you assuming that I will not take that on account? I have not reached that far. Why the bar has become so impatient these days? What is the reason?
As lawsuit indicate that.
Sit down.
Lawsuit indicate that in view of the.
Sit down. Yes. লিখিলা to refer to the office memorandum dated 11/3/2019, issued by the Deputy Secretary to the Government of India, whereby the master circular issued by OM dated 21/7/2014, which has been suitably updated, has been circulated for which has been consolidated. Wherein the instructions on probation / confirmations have been consolidated. Stop. Clause 7 and 8, or only 7? 7.
Yes, ma'am.
Clause 7 of the said Master Circular on probation and confirmation in central services is reproduced hereunder for ready reference. C2C, page 94. C2C, huh?
At 97 also, the learned senior counsel had relied on termination of probation of 19.
97?
Yes. 19, termination here.
Hmm?
The employer should be confirmed, he should be given, this one also he relied on. A probation should not make satisfactory progress.
So he has not taken me to 19, Mr. Sharma. 19 was not placed. Anyway,
19 को दिखा कुछ लेकिन
reading of the aforesaid clause indicates that in the event the performance of the probationer is not satisfactory, an opportunity in written is required to be given to the probationer in order to give him an opportunity to improve his performance. Stop. It appears from the affidavit in opposition filed by the respondent's authorities, AIMS, on 1/10/2024, that the petitioner, having found unsuitable for confirmation while on probation on the merits of performance, his services ultimately had to be terminated. Stop. Paragraph 12 and paragraph 16 of the aforesaid affidavit in opposition is reproduced hereunder for ready reference. The 12 to paba at page 158, more yellow flag 12 likhi disu, or 16 to paba 159 of the paragraph likhiba moi yate ko indicate kori din jiman ase 12 or 16 reproduce kori. What emerges out is of services being found unsatisfactory. Stop. Admittedly, no written warning has been given to the petitioner to improve his service, to improve his performance prior to issuing the termination order. Next paragraph. Though Mr. Gogoi, by referring to the All India Institute of Medical Sciences Regulations 2019, has submitted that during the period of probation, the appointing authority can terminate the services of the appointee stroke probationer at any time without any notice or reasons being assigned, comma, the termination order ought not to be interfered with, is, in the opinion of this court, a fallacious argument. Stop. Don't say fallacious argument, is misplaced in the context of this case. Some solace to you. Is misplaced in the context of the present case. Stop. Clause 7 of the office memorandum dated such and such, and the provisions of the All India Institute of Medical Sciences Regulation 2019 can stand together, and the said office memorandum is not in violation of clause 25 of the said regulation, inasmuch as clause 7 merely gives the right of opportunity to the probationer to improve his performance in the event the respondent finds his performance is shortcoming. This is in consonance with the principles of natural justice. Stop. Dhingra?
Yes, madam. I have given, madam. Para 28. Page 24, running page. Running page 24. It will start from para 28.
Yes. All right.
And then with contractual, it is with para 40.
Reference is made to the decision of the apex court in the case of Parshottam Lal Dhingra versus Union of India, reported in 1997. Reported in 1958 SCR at page 828. Paragraph 28 of the aforesaid judgment is reproduced hereunder for ready reference, quote unquote. though Mr. K. Gogoi, Leonard CGC, has placed the relevant file, file number 2-356/2023-24/AIIMS/Guwahati/establishment/personal, personal, comma, from where? No, কি বুলি start কৰিলা? Do Mr. Comma, drawing the attention of this court to letter dated 19/9/2024 issued by the executive director within bracket respondent number
5.
To
Here is not 4 also.
respondent number 4. To the effect that in addition to the 1-month notice period provided under the impugned termination order 11/9/24, comma, the petitioner shall be paid additionally for 2 months of pay in lieu. Stop. Comma. This court is of the considered view that the same shall not rectify the termination order dated 11/9/2024. Stop. Admittedly, the order, impugned termination order, is passed without giving the requisite 3 months notice on 11/9/2024 as required under the termination order. Stop. That apart, apparent that no written warnings as required under clause 7 of the office memorandum to improve the services, to improve the what was that term? Improve the performance. To improve the performance was also provided to the petitioner. It further appears that the services of the petitioner was terminated upon being found unsuitable for confirmation while on probation on the merits of performance. That being so, this court is of the opinion that before proceeding to issue the termination order, comma, the petitioner ought to have been given a written warning so as to be provided an opportunity to improve his performance in accordance with performance. Stop. However, be that as it may, this court is of the opinion that this petition can be disposed of with a direction no, don't say that. In view of the above, the termination order dated 11/9/2024 is hereby set aside and quashed. It is needless to be clarified, next paragraph, that the respondent authorities are at liberty to proceed in accordance with law. I'm going to edit this order because it's difficult. So in case you don't get it today, probably on the next working day, it will be done. All right? Next working day is you required.
Yes, because that is what I have said. The primary stand is that since I can't commit to the termination.
That's why I use the word fairly.
No. My lord.
When I addressed, when I was quoting your submission. I said you very fairly you have submitted. Only for that.
My lord has said no, next working day we'll get the order copy.
I'm not sure you will get it, but just keep it.
So,
Because you will need some editing.
If my lord, because the court will close by tomorrow and my termination gets over on 10, so the aims may be instructed.
No, we have a working day before that. Our working day 8 तारीख और कितना है? काली हुआ है तो और हाथ 8. You will get it before that. I will try to, but you see, they have to type it, and this is not the one disposal order. I think I have disposed as many as about 12 cases and all long orders. So they will also have to type. There is a time when they will go home. You see, you people go at 5, but my team, they are here sometime till 9:30. But there is a limit to what time they can stay in the court. No, they also have a family. So once they give it to me and I edit it, thereafter it will be online. Okay?
I put on. Yes, Lossi has taken the brief. So Lossi 105 for other purpose. Page number 105 Lossi for other purpose. Lossi.
What is there in page 105, Mr. Gogoi? Page 105, I had not referred to it.
Not related in this case, Lossi. Just time indicate Lossi. 105 Lossi.
Yes.
31 Lossi. For a moment, just
term of office of director.
For other purpose, Lossi.
Oh, 65 years.
That's why Lossi I indicate Lossi. Lossi.